Hope everyone had a wonderful 4th of July. Our first item on the agenda is citizen concerns. If there is anyone who would like to address the board on an item that is not already on the agenda, please come forward, state your name and address and your concern. And please be aware we have a 4:35 p.m. set time for a property sale.
I wasn't sure about whether or not it was on the agenda, if it could be addressed or not, but my concern was about the ban of guns in the courthouse.
Okay, that'll come later. If it's on the agenda, we prefer that we receive input at that time.
So it would be at the end of, or at that certain time?
At that certain time.
Do you have an idea of what time that might be, like near the end?
I don't control.
Okay, then I will wait.
Thank you.
I'm Randy Riediger from Hinton, Iowa. I'm proposing a hog barn in Banner County. You'll have to vote on my subdivision. I prepared a letter that you may pass out here this week. I know it's on the agenda for next week, but I'd like to be able to have you guys ask any questions of me that you have, and be able to contact me in between if you have any that you don't get answered tonight. The barn is going to be a 4,800 head nursery, which equates back to the DNR rules of 480 head animal units. Now for this barn here, actually I do not need any setbacks according to the DNR rules, but we do have 1,250 feet from the closest objecting neighbor. I have 1,100 feet from my brother, which has no objections, and we are trying to put a barn in so I can bring some kids back into the operation. We're small family farmers. I take care of hog barns now. The reason I can't put it next to my house, I already have 2 hog barns there already. So I'm not afraid to live next to them. I asked my wife the other day, I says, how many times a year do we smell these? I was going to say 8 or 10. She said 4. She surprised me. So if you have any questions, feel free to call me. My phone number's on the bottom. And the second page there is the list that all the people that went to the first meeting at the zoning board. And the zoning board did approve it.
Okay, thank you.
Thank you.
Mr. Gill, should we move to receive this?
Yes.
I'd move to receive the letter.
Second.
Second by DeWitt. Discussion. All those in favor say aye.
Aye.
Opposed say nay. Passes 5-0. Are there any other citizen concerns? And we have 1.5 minutes before our set time.
Walt Reitholt, 2605 Glen Ellen, Sioux City, Iowa. I have family and land beside this property. This is a hog confinement without restraint. What that means to you, every one of you it can be by your house. Wow.
Can I ask you a question? Is this the letter that he just sent, that he just presented? Is that
I don't have knowledge of what you're talking about.
What property are you talking about?
This Riediger hog confinement on D12 on Delaware Avenue.
The same property? He just presented a letter. It's going to be on the agenda for next week. That would be the time to address the board on that. I'm the county auditor. I'm just saying for procedural purposes, that's what.
I'd like to give you a heads up. Take the opportunity and go out and look. And think of safety. Safety is bad. Health of the neighbor is bad. And if you need a person to talk on health, I'll bring a person. You want somebody to talk on health?
Thank you, sir.
But this, you understand that this will be on the agenda, and that will.
Yeah, I understand where you're at. Okay. I want to give you a chance.
Sure. No,
go forward.
Yep, I understand that.
Thank you.
Thank you.
Mr. Taylor?
And, sir, your contact information, sir? Your contact information, I assume, is on the back when you signed in?
Yes.
Okay. Thank you very much. Appreciate it.
We are now at a 4:35 p.m. set time. Item number 10 from Board Administration. This is a public hearing and sale of property parcel also known as 703 Ross Street. Public hearing is now open. Before we receive bids, is there anyone who would like to speak for or against the sale
We just approve the agenda quickly.
Move approval of the agenda dated July 11, 2017.
I'll second the motion by Taylor. Discussion. All those in favor say aye.
Aye.
Opposed say nay. Passes 5-0. Thank you. We are now in a public hearing. Is there anyone to speak for or against the sale of this property before bids are received?
Hearing none, Mr. Chair, I move that the public hearing be closed.
I'll
Second.
second the motion by Mr. Taylor. Discussion. All those in favor say aye.
Aye.
Opposed say nay. Passes 5-0. We are now receiving bids for the property also known as 703 Ross Street. Is there anyone who would like to bid? Please come, state your name and address and your opening bid, please.
Aloha Grant, 707 Ross Street.
And your opening bid?
$250.
The minimum bid on this property is $2,000. Is that correct, Heather? It's $21.38. So that is the minimum opening bid. Would you like to bid that?
Where do I go from here? Do I have to bid that?
No, you don't have to bid that. That is simply the opening minimum bid that was published in the board packet.
What happens if she bids less than that? I think it's her question.
That would be a question for our public bidder.
I would assume we have some way of setting the minimum bid.
With notice.
Yeah.
Well, the property has been neglected for a long time. I know the last few days or this last week you guys cleaned it up, but, you know, there's a lot of issues there, and it's right by my house, and I just would like to purchase it to take care of it.
I understand. Heather, did you have something to add?
It's been published with a minimum bid of $2,000. It has to be at least a minimum of $2,000.
It has to be.
Well, we
That was the
could we
minimum
not
bid that was
republish
set.
it?
Yes.
That?
Yes, we could republish it, revisit the
Yeah.
minimum bid if there's no interest tonight, and
Yeah.
you are still interested. You can work that out with Heather.
And how long would that take?
A couple weeks, Heather?
Yep, be 3 Tuesdays from now, so whatever date that is. I'd
I
have to
think it's
go-
worth waiting 3 weeks if it's the legal way of doing it, so.
Yeah. Yeah, if you're not interested in bidding that, we'd have to revisit it with the board, and I would be in contact with you this week, either way.
No, I think it's a little bit high myself.
Well, so, yeah, we'll have you work together with Heather, and then we'll have to republish it with the different minimum bid.
Okay.
Okay.
Sounds good.
All right,
Thank you.
thank you.
Thank you.
If nobody else bids 2,000.
No one else to bid on this property? Mr. Gill, a motion to defer indefinitely?
Or delete.
Just say there were no bids.
There were no bids. Items 4 through 9 constitute a consent agenda of routine action items to be considered by one motion. Items pass unanimously unless a separate roll call vote is requested by a board member. Item 4 is approval of the minutes of the June 27 meeting. Item 5 is approval of the claims. Item 6 from Board Administration is approval of a notice for a property sale resolution for a parcel also known as 2711 7th Street, and setting that for Tuesday, July 25th at 4:35 p.m. Item 7 from the County Auditor is to receive appointments of David Colbert and Kathy Scholl to the Danbury City Council. Item 8 from Human Resources includes Item A, approval of memorandum of personnel transactions. Item B, to authorize the chairman to sign the authorization to initiate hiring process. And item C, termination of the following policies. Policy regarding termination of employment, policy on reemployment, and the fire and emergency rescue service policy. For some background on this, you can consult the minutes of the Policy Review Committee in the backup, explaining the rationale there. Item 9 from the County Treasurer is the 2017 tax sale report. Could I ask Treasurer Clayton to come up and give a few comments on this, and if the board members have any questions after you walk through what this means?
Well, it's the first time we've ever done this, but yep, the tax sale deputy put together a report. So if you got any questions, just ask away and I'll answer them without going through and explaining each line item. So,
Could you describe how it compares to last year, perhaps?
very similar to last year. Top section up there is the tax sale bidders that won a bid, and it lists how many parcels they won, the amount of dollars received, cert fees, and then the total dollars. Next section down, it shows the private sales and then real estate certificates issued to the county, real estate or mobile home certificates issued to the county for a total certificate count of 803. Right down towards the very bottom down there, it said total items published. That was 1381 parcels. That's what went to the publisher. That's what was published. By the date of the sale, June 19th, we were down to 944 that were still unpaid. And those what actually went on the tax sale were 944. We had 1,415 bidders, which is unusual. When I first started here and we did a live auction, we had around 300. This is the highest number I've ever seen. We collect fees from these bidders, and then also we collect a certification fee when they're issued a certificate. And so the total revenue was minus the publishing cost, which was $25.27, $48,047. And the bottom section down there is a percent bid down. In the state of Iowa, you can bid down properties down to 1%, and we only had 15 bid downs, which is unusual too, because the first year we did online tax sale, there was almost 100% bid down. So the buyers are getting savvy now, and they know that a bid down doesn't do them any good, because if they do take D, they only get 1% if they bid down to 1%. Tax sale is mandated by Iowa code, third Monday of every June. Anything that doesn't have taxes paid as of the third Monday in June, we have to put up for public bid. We chose to do this 3 years ago in an online system. Pretty much a no-brainer. It saves county money, it saves county time. And we still collect pretty much what we used to collect at a live auction. So.
Any questions? Thank you for the report.
Yep.
This concludes the consent agenda. If there's a motion to approve the consent agenda.
I will move it.
Second.
Motion by Raddick, second by Taylor. Discussion. All those in favor say aye.
Aye.
Opposed say nay. Passes 5-0. Item 11 from the Board of Supervisors and myself is an action item, approval of employee handbook change to comport with board action June 27, 2017. This formally approves a change in work rule number 24 in the employee handbook regarding lawfully carried firearms according to Iowa code. On June 29th, Human Resources Director Gilliland emailed employees notification that work rule number 24 regarding prohibited conduct is updated due to board action taken June 27th. And it was revised to read, possession of dangerous or unauthorized materials such as explosives or weapons in the workplace, prohibited, and then to add lawfully carried firearms are permitted in accordance with Iowa code. Having consistent language between the handbook and existing policy is important to guard against the lawsuits. This change not only reflects the board action, and this change was discussed at the last board meeting we had, did not receive any comments elaborating upon that at that time, and it assures the handbook comports with law. But formal approval of this change is requested and provided here to ensure complete and transparent documentation. So I would move to approve a change in the employee handbook to work rule number 24 to state possession of dangerous or unauthorized materials such as explosives or weapons in the workplace in the context of prohibited conduct, and then lawfully carried firearms are permitted in accordance with Iowa code.
I'll second it.
Second by Radig. Discussion. First from the board. Sorry.
Michelle.
You know where I stand on this. I still don't think that I want to be the one telling the judge at the Supreme Court that I'm going to violate his court order. But I'm interested in hearing from the sheriff.
Okay. Sorry, I just couldn't hear you, Supervisor Potamow.
Say what?
I just couldn't hear you down there, so I didn't know if you were making...
No, I just said that. I think everybody knows where I stand. I just don't want to be the one going on record as violating a court order from the Supreme Court of Iowa. So,
Pat Gill.
besides thinking it's a bad idea.
Pat Gill, County Auditor. Before I start, I think there's some confusion here with these folks. They wanted to address it in citizen concerns, and I think they were talking about the overall ban. I think you understood it to talk about this policy decision. So how would you like to handle that?
Well, we can't go back in the agenda, so if they would like to address their concerns during this item, I'd be okay with that.
I'll just explain what is going on. Is that the last meeting imposed the ban. But the folks, what is on today is a separate issue on the agenda. It's about the policy involving employees being able to bring firearms into the county. So what the chairperson has just said is that he will allow you to speak on the overall ban at this point.
State my name and go.
Yes.
Jackie Stellish. I would like to begin by thanking the board for taking time to address citizen concerns. The concern I will address is the vote by our board to ignore the Supreme Court's supervisory ruling to ban guns in the courthouse. There are a few things about myself, though, I think you should know. I want you to know you were looking at the oldest daughter of a Vietnam vet. I grew up watching Tour of Duty in China Beach in front of a giant stone fireplace with deer heads on the wall. I have seen Platoon too many times to count, and every Rambo movie at least twice. My grandfather owned a gun shop. We would visit him in the summer, and I would help him set the sights on the rifles. I traced my uncle's name on the wall in D.C. and gave it to his oldest son. I always stand for the Pledge of Allegiance, put my hand over my heart, and taps at military funerals would bring a tear to my eye every time. Most of the men on my dad's side served in the military, so I've heard taps far more than most. You need to know these things because I feel many people immediately judge someone as a snowflake when they caution against guns in certain places. Just so you're clear, I am no snowflake. But I can count on only a few people I trust in my immediate vicinity with a gun. They all have two things in common, though. One, they know how to use the weapon, and make no mistake, guns are weapons designed specifically to kill things. So knowing how to use it may ensure that you don't accidentally kill something that was not meant for killing. Two, they respect life. Those two things are crucial to me and my safety when thinking about who stands next to me with a gun. By allowing anyone with a gun to walk into this building, you cannot guarantee anyone's safety, and I would argue unless someone plans to shoot someone or something in the courthouse, the gun serves no purpose. Nobody needs a gun to vote, to serve on a jury, or accomplish any other task in this building. Unfortunately, right now, anyone can take a 90-minute class to fulfill the requirement to get your Iowa permit to carry's weapon. No test and no shooting. All you do is show up with $60. How many other licenses can you think of right now where it costs double or triple the amount of time and money to acquire? Driver's ed is a month long. The cost is near $400. Now, some of you may be worried about a kid driving a car without that much training, but when was the last time a kid with only a car opened fire in a crowd and killed people within mere seconds? I urge you to reconsider your vote. Listen to our professional law enforcement. If blue lives and all other lives do indeed matter, like they do to me and you, they deserve the respect of the board and the people of this community who have a right to be safe when they're in this building. The Iowa Supreme Court did not make the supervisory ruling just for fun. One reason is not too long ago, an Iowa man angry about his property taxes was fatally shot during a public meeting after he pulled a gun from a briefcase and pointed it at the county assessor. How many meetings have you had here where people have heated arguments about these kinds of issues? Also, how many high-profile cases are heard in this building? Can you guarantee a jury will not be intimidated by people walking into a courtroom with guns? A quick conversation with the clerk's office with the Iowa Supreme Court will confirm this real threat. They can tell you all about the cases where juries were indeed threatened and intimidated during high-profile cases when people with guns walked into the courtroom. I leave you with this. If our professional law enforcement is ignored, and guns are allowed here, I will steer clear of this building, and I will seriously consider my own counsel and not take a jury summons so darn seriously. I am not afraid of guns, but guns do not make me feel safe. People who have had proper training and have respect for life do, neither of which anyone can guarantee, but at least I would have a little peace of mind when exercising my right to vote and serve on a jury. Thank you for your time.
Thank you.
Due to my having only about an hour, I gotta leave at 5:30. Could we move this citizen concerns back to the end of the agenda so we can move through the agenda? I mean, debating House File, I forget the number, 571? 517. That was done at the State House. I mean, it's pretty clear what they intended when they passed the law. You had Senator Chapman saying he voted for it because he believes public buildings should be allowed for the public to have their rights to own and carry a weapon. Those that voted against it said specifically they voted against it because they didn't want weapons in courthouses. It passed both the House, Senate, and the governor's signature. It was pretty clear what they signed into law, and a court order is different as far as differentiating courtrooms, courthouse, and you know, I think we're debating something that's been decided, and I would like to maybe move that to the end of the agenda.
Well, Supervisor Radig, I'm doing my best here to accommodate the people that, you know, decide to show up today to give their thoughts on this, while at the same time, I hope the room understands this discussion was held a couple weeks ago when a lot of these concerns were raised. So
sure,
in order to strike some sort of a compromise, if I could ask for, we've had a position statement from one side of the argument. If there's another from the other side to be allotted 3 minutes, then we do need to move into the item that's on the agenda, and then we'll return to citizen concerns at the end of the agenda. Because we do need to move on our items.
Lisa McNeil, Court Administrator. So are we still talking about rule number 24, which was on the agenda?
Yes.
That I would like to speak to?
That's the item we're on.
So can we speak to that?
Yes, yes.
Can I speak to that now?
Yes.
Okay. Lisa McNeil, District Court Administrator, and I'm very concerned about the change in the rule because I think it puts employees in an untenable position, because with the Supreme Court supervisory order that indicates all court areas shall have weapons prohibited, we only have one front door to the courthouse. We use the lobby for jury check-in. We use the basement for jury orientation. We have court on second floor, and some of the county employees have to pass through all these areas to get to their respective areas. So it's not like we can separate, here's the court area and here's a county-only area. So I think we're putting employees in a situation of possibly being in violation of a supervisory order by the Supreme Court, even though they might think they're following county policy. And I just wouldn't want to see employees being put in that position.
May I respond to that?
Mr. Taylor.
If I may, and this is more a philosophical discussion, but I think, to me, the ire of the situation is that Mark Cady has put us all in this situation. And the reason that I say that is that what he took upon himself to do in his supervisory order was to contradict Iowa code. To do so knowingly, just 10 days ahead of that law going into effect. So we have what people have posited as county policy being out of step with the supervisory court order, but it's really the Iowa law. It's really Iowa code that's out of step with that order. And what this really gets to the heart of this whole thing is whether one Supreme Court justice, in my mind, pretending to be a legislator, and a supreme one at that, has the power on his own, not the Supreme Court hearing a case on a constitutional basis and deciding whether a law that's passed is constitutional or not, but whether or not Mark Cady himself can have what I think is the audacity to write law, which I was very appreciative that the Sioux City Journal editorial board recognized that that is a question. And so I just want to say that that is where I think the blame in the situation belongs.
Well, I don't know about trying to assess blame, and I think we're going to have to leave it up to the lawyers and smarter people than we to decide which law is supreme, because I think Justice Cady took the Constitution as being supreme over all law, and using the powers vested in him via the Constitution to take that. So very good questions, and I don't have the answers today, but I do know from a practical standpoint, we're putting employees in a very awkward situation.
And if I can just respond, and you know I have all the respect in the world for you and what you do, I believe that he ignored the Constitution. I believe that he ignored the law willingly. I think he should run for the legislature. And I think that when you have duly elected officials, I mean, my goodness, the governor, the longest serving governor in the history of the United States, couldn't do what Mark Cady did in writing into law. And here's the irony of this. From January 4th of 2015 to July, nobody on this board, and I know there were two of us, moved to lift a weapons ban. Now, why is that? Answer, because as of July 1st, there was a change in law, and we were compelled to follow the law. I wish our Supreme Court justice had as much respect for the law as that, but that's the position that we're put into, and it's to follow the law or to be sued, and that House File 517 is very clear on standing in such an instance. So
I just had to make sure we were understanding. Thanks.
If I may. Excuse me, one thing first.
Mr. DeWitt first. Mr. DeWitt.
Abigail? Yes, sir? I was obligated to say nothing 2 weeks ago. Can I finally speak at this meeting? Or do you advise I don't speak at this one?
You should not speak in any situation in which you have a conflict of interest. The vote has already been taken.
Mm-hmm.
So, ultimately, it's your decision, but
I think technically on an item on the employee handbook, we all have a conflict of interest.
Well, I have some comments for the young lady here, but if you advise me not to say anything, then I'll hold it.
the question is about is about the employee hand. That's the item on the agenda. You don't have it any more of a conflict with that than any other employee does.
Okay.
Answer your question.
Mostly.
Mr. Potterbon. Sorry, did you?
Nope, I'm going to hold for the moment.
I was just going to address one thing that Mr. Taylor said, and I know philosophically everybody's going to argue about who does what, but the way our system was set up of government is the legislature, he's correct, they make laws. The courts interpret laws. And I know from my years in law enforcement, when a court orders me to do something, and I remember years back when the sheriff's department was ordered to transport a prisoner, they didn't want to transport. They said, well, if we don't do it, they said, if I don't drop my order, then you're in contempt of court.
But Supervisor Potterbon, I just say there was no interpretation of law in this instance. An interpretation of law, and it was a good example for my seventh grader to understand, what the court does is they interpret with cases. A case comes before and it's argued for and against. A Supreme Court justice doesn't have the right to sit down and make law. That's the difference between the interpretation argument.
If I could finish
Sure.
my argument, please?
Yep.
I thought that's how we did things here. The one thing I would say is that from what I read of Mr. Cady's supervisory order was he was interpreting the Iowa Constitution and his duties that he said were included. Now, I don't have a law degree, so I'm not going to argue whether he has those duties. You may have a law degree, I don't. So I'm not going to say whether or not he's correct in interpreting his duties. I'm going to take it that he's the judge and he says it's his duties, and that's his job, is to interpret the law and the Constitution. And I would say if Sheriff Drew or one of us gets sued, I would take this all the way to the Supreme Court myself. But
In which they would probably have no standing, but.
Sheriff?
So I'm not sure where I weigh in on this, because I wasn't here last week when this was debated. I thought I was in good standing with what was going to take place. So I'm not sure how I'm to approach, but allow me a little bit of leeway. Okay? So we have a security meeting that meets. It's a board chairman usually, or his representative, and chief judge, county attorney, district court administrator, Lisa McNeil, some from the sheriff's office, chief judge of juvenile courts, and there may be a couple others. And this committee has come about and been in existence, I know, for well over 20 years. And the security committee is tasked with trying to keep the courthouse safe. And part of that is the courts. So in, I believe, 2013, courthouse moved forward to have courthouse security. Marty's quite familiar with that.
I remember that.
Debate. That went to the Iowa PERB board. Two gentlemen ran on that the sheriff should have control of courthouse security. And I understand the law changed. But the mere fact, nothing changed. I talked with Dan Dawson today. Dan was the author of the bill. And I said, Dan, I hate to quote you from a paper, so I'd rather just ask you this question. Are we to get rid of courthouse security? He said, absolutely not. Absolutely not. Because you already had it. He was quoted in the Des Moines Register, I believe, or another paper. He gave an example of Polk County and Pottawatomie County, where he's from. They have courthouse security. They have metal detectors. They have security. They provide them. It's too high of a standard to be adversely affected when we're providing you that security. So you come into the building, I don't know what argument you would have, because we're giving you security. No one can come into this building. The only armed people are law enforcement or those that are working here, that are part of the sheriff's courthouse security. So there is no adverse effect. It's a high standard to reach. I don't know how you're going to get there. So he said, told me the intent of the law was not to get rid of a weapons ban. We have gone to the point of having one point of entry, no weapons, control point, x-ray machine, conveyor belt that checks all that. We are on top of the game. And there's really no reason to go back, and I think of the integrity of the court. And I know I hear the stories. I listened last week and I was really frustrated, as I'm sure you must have been too on this topic. But the mere fact that to respect the court, and that is a bulk of this business. And jurors being afraid, I've run into hundreds, just as you must have run into hundreds and told your other stands. But they don't want to be a part of a jury because they read the paper and they see what happens. So they're nervous. And to go backwards in the threats that we've had against county attorneys or judges, it hasn't got, that I know of, to Board of Supervisors, but I know Julie Conley might have been worried when all the taxes were going up. And she was pretty happy that we had courthouse security. This affects a number of people in this building. And I think we're taking a huge step backwards. You're not taking away anybody's rights. Listen, I'm a Second Amendment sheriff. I'm telling you why I'm a Second Amendment sheriff. Only 2 sheriffs in Iowa would give their file when you applied for a gun permit back to the party that asked for it, filled out. We kept the other as an investigative file. So the media or somebody couldn't ask for a open records rule. I protected them because I believe that their identity should be kept safe. But the legislators, which I agree with, said, guess what? We're going to make a new law that we're going to make sure that their information can't be given out anymore. Because I didn't want somebody to come wondering where Joe Smith lived and had a gun. So I protected that. I'm a Second Amendment sheriff. This has nothing to do with the Second Amendment. This has to do with the integrity of the courthouse and the security that we fought for, and I believe the employees here want. But maybe are a little too scared to come up. I'm elected. I'm here till 2020, and I hope another 4 after that. But if not, I gave it my best. And leadership and integrity aren't based on popularity. If it was, it wouldn't be here. These are tough decisions that you have to make, and you have to think about the safety of the people that work here, the integrity of the courts, and you had a Supreme Court order. You may not agree with, you might have thought it was an overreach, but I have a district court order. Did you all get that from Judge Hoffmeyer? I'm going to hand it to you so you can read it. Judge Hoffmeyer, who I answer to, because I'm an officer of the court. 71 responsibilities the sheriff has. 71st is, kind of says, and others, but 70, in that it says that the sheriff will execute orders from the court. I've told you before, much rather be held in the contempt of the supervisors than the contempt of the Supreme Court. I might add, recently, I'd rather be held in contempt of Matthew Young's Facebook posts that constantly are opt. I find it a little bit disheartening. I find it troubling, sophomoric, and a little bit embarrassing for you. We may not agree, but to post all that is troubling. That's not how professionals do work. You're the chairman of the Board of Supervisors, not the chairman of the sophomore debate team. So I find that very offensive. You and I could have dialogue. We can talk. Friday, I talked to you on the phone. I thought we were good. Monday, I thought we were good. I think Judge Hoffmeyer in his letter thought we were good. On Tuesday, an hour and a half before, all of a sudden something changed. That's troubling. You had a chance to talk. You challenged me on why I said it was political. I think you know why it's political. Because you received a lot of phone calls. But you should have said, hey, this isn't a Second Amendment issue. This is an issue about protecting those that work here in the courthouse. You said, Mr. Raddick, that they made this new law. This law doesn't say that you can't have courthouse security because we had it. If we didn't, that's a whole different thing. So my point is exactly, why lift the ban?
Can I respond on one point?
Sure.
And you know I have a ton of respect for you, Sheriff.
Likewise.
And I want to keep all of this above board. The only, on the issue itself that I would ask are two questions. One, we don't have it across the street at the law enforcement center.
No,
So that's an example. I think when Judge Hoffmeyer and the authors of this bill, the poster example of how one would be adversely impacted. You said, well, here we have courts that are protecting, or protected by courthouse security. You don't have it across the street at the law enforcement center. You don't have it at Trusford White. And so someone being disarmed there could make a very good case he or she is adversely impacted. Now, I may not like the law. I may think the law is silly. And I think the evidence is that this board didn't act for the first 30 months in which they could have. At least two of us could have said, we want to lift the weapons ban. We come up to July 1st and feel compelled to, based on that going into law. So that's where I'm at. It's not, on whether or not we should have courthouse security. I think it should remain in place. But the idea is whether or not this board is conforming with the law, or whether we think that the supervisory court order, which I think even members of the judiciary understand is a complete overreach. And I think we've heard as much. So that's where I'm coming from, just so you know, is that.
Well, and, that's the great debate, and that's why we'll be in court to figure it out. But I would have never thought that we should be battling for something that is simple as this. Your opinion and mine are totally different. So I guess when you're at impasse, that's why you have the courts to decide who's right. And I think I'm on solid ground. Obviously, you think you are. But that doesn't mean that we have to, and I compliment you for your taste and good demeanor of discussing it with me. Same with all the board members. I do take great exception to you, Matthew. I really thought you'd took a higher road than that. I thought you took a lot of pot shots that were every day, tongue in cheek. If the judge orders me to do something, I mean, you know what that is. That's uncalled for. You're better than that. I really believe you are. But I think you got caught up in this whole whirlwind of trying to put me versus you.
Really?
It's not what it's about.
It's not what happened at all.
Well, I am going to call the question on the employee handbook change because can't. All right.
So if we can,
'Cause I feel like we're talking about stuff not related to employee
Well, I
handbook.
know you got time at 5:30. You got to be here, but this is important because this is about the employees of the courthouse. This is about courthouse security, and this is a far more important than whatever you got going on tonight.
if I can just ask a question to kind of recenter us back on this. Am I of an understanding, and this may be for county attorney?
I don't think he can answer.
Is this indeed a supervisory court order? And I'll plead my ignorance, I may be the most ignorant person in the room.
Don't feel bad because that leaves the two of us.
Is this a letter intending a court order from the chief district court judge? Or is this, in fact, the text of the court order? And the only reason I ask is because I've heard that there may be in that court order allowance for employees. I don't know, but to me, as a simple layperson who does not have a law degree, this doesn't look like a supervisory court order. This looks like a letter, but I don't know. Is there someone who can answer that?
Well, and once you have case law from 2006 where the courts decided they didn't want to pay for security, so they said that the courthouse is separate and they don't have jurisdiction over the entire courthouse and only the courtroom.
No. That's not the answer to my question. Is this document supervisory court order, or is it a letter from the chief judge stating that he intends to write one that comports with a supervisory court order from the Supreme Court?
P.J. Jennings, County Attorney. Thank you for the question, but I'm going to respectfully defer on the position of the County Attorney's Office. I've stated I have a conflict. I'm fundamentally against weapons being brought in the courthouse. I'm not going to openly disagree with the board, but we're not going to answer that question due to that conflict.
Here's there's a whole nother issue. Somebody should be able to either represent the chief judge and say, this is a letter, and this is a supervisory court order, and they're not one and the same. And I don't necessarily, I respect your position, think it's a conflict of interest to say, hey, you simpleton, this isn't a court order, this is a letter, or this is a court order, because it makes a big difference as a body in trying to decide something if we don't know what the thing is in front of us.
Well, it says that a more formal and detailed administrative order is coming and that this letter is a request. Now, I know I'm not a lawyer, but I can read words.
Right, and so I guess that's the...
The request should be considered effective immediately, is what I read. And
I actually have the same problem with the same wording you do, Jeremy. The fact that he made it a request. Sounds like a friendly letter from him to you. And I'm not going to guess what he meant when he did it, because I'm not him. And I do, if this was going to be a court order, I would really wish that he said, I'm ordering you as Chief Justice of this, and that this order shall be enforced immediately. But when he says this request should be enforced immediately. Good luck being in between that rock and a hard place there, Sheriff.
Well, that's why I'm going to stick on my guns. And
I appreciate the position you're in as far as trying to carry out. I mean, you've got a decision to make. We obviously have one as well.
Right.
And I don't think there's, at the end of the day, we're trying to follow what we believe is the compelling interest of the law. You're following what you believe is the compelling interest of the supervisory court order. We are.
Right here, and that's why when we get to that next point, then I'll have to have
next.
That's the next one. But that's kind of why we're where we're at. And that, so quickly in closing, in all situations, we have to work together. We can agree not to agree, but what we can't have is things thrown out to others, show that we're not working together. That's the troubling part. And I think that it'd be best that those that are here that wish to give their piece on, just like this young lady did, on why she doesn't believe weapons should be in the courthouse, you should allow others to speak. Just as if there were some that should, I think you should, and you have in the past, and I congratulate you, let everybody talk before. I don't know if people understood what was coming down. Don't give ourselves such credit that people review the agendas. Usually it's after the fact, and that's why you get people that are coming. So I really would I mean, I can't tell you enough. The fourth leading cause of homicide in the United States is workplace violence. So the last thing you need to do is allow employees to come in with weapons. Just as the same as we shouldn't allow people to come in because we're protecting this building. So as Dan Dawson said, you're not being adversely affected because the sheriff is protecting you while you're in this building. Where the person who has that right to carry their concealed permit should carry all the time is when we're not there. But when I'm here and my people are here, I can't distinguish when bullets are flying. Who's the good guy and the bad guy? Ask my deputy who's just gotten a shootout. You know, spray and pray. And so allowing something that could be as contentious as things that we have in this building, even when we have security people here that get out of control, people get upset over child support payments or coming to fill out a domestic abuse. No weapons, but we've had fights that we've had to break up. You put a weapon on somebody that's very upset and things can happen that I don't think it was the intent. In 2011, they changed the law to shall carry. I was for it. There's a good idea. But the problem with that I didn't see was under shall carry. Then we started allowing people that were pled down from felonies to serious misdemeanors or aggravated misdemeanors to carry weapons. And so the intent of the law was good, but then all of a sudden, because the courts get overcrowded and plea bargains happen, the next thing you know, I got people with fairly extensive criminal history that can have a weapon. So the day and age of just law-abiding citizens have a permit isn't always true. I've fought a few, and county attorneys gone to bat for us, but it is shall issue. So, in closing, I really would like you to open your minds and trust the sheriff in this situation, and trust the courts, and trust the county attorney and your employees and potential jurors, those that use this building, and let somebody else challenge us. Then we're not going to be out any dollars because it's such a high mark to get over, adversely affected. You're just not. Thanks.
First, I'm Pat Gill, County Auditor, and I just wanted to address first is Supervisor Radig's question to call. The question is that, the reason I said you can do that is you have your agenda rules that allow for people, and it says everyone will be allowed to speak.
Okay.
And then, but you can move to suspend those rules,
Sure.
and then you can call the question, and it takes 4 votes.
It'd take a 4-person vote, yeah. It's 2/3 or whatever. So.
Right. Okay.
We also have given a lot of leeway in our rules that mirror the Sioux City Council that say 3 minutes.
Yes.
It's hardly ever been enforced, and certainly not for the sheriff.
Yes.
So can I get a number to call in on here in about 10 minutes?
I didn't understand.
So I can call in and...
We certainly have that capability. Whoever's sitting in that chair needs to answer the call, is that correct?
Yes. The bylaws say if he is necessarily away, It's up to the rest of the Board of Supervisors to determine if he meets that standard.
He does. He's not here.
Pardon?
Well, if he's not here, he meets the standard.
That's up to you folks.
Well, I have to leave for work to be at training in the Twin Cities, and I have to leave at 5:30 because there's 4 other people dependent upon me going at that time.
Go ahead and make your 3-minute statement.
Well, I'm going to ask some questions here because I wasn't, once the county attorney declared a conflict, I haven't been able to ask some questions about how this actually is going to, I want to get back to the item that is on the agenda, talking about employees. First, I wanted to ask the sheriff what this means, what he thinks it means, and what the impact is going to be if you were to pass the proposed amendment to the employee handbook. Because it does say is that, I guess what it centers on is that you said that there's a court order that says that you can't allow guns into the courthouse.
Right.
But there is some issue here with the Supreme Court order says the order does not affect the authority of county or city officials to determine the appropriate employment policies for their employees in this county in city offices located in courthouses or other justice centers.
So my legal advisor is not here today, and I'm opposed to it. My legal advisor's not here today, and I think he says I can't cherry pick which ones I can, orders I can go by. So that probably means that employees can carry, though I am adamantly opposed and we disagree. I'm not going to fire him. He's my lawyer. I agree with him on a lot. This I might not, but I have an attorney that you'll be paying for.
Chairman,
Yes.
can I just ask you, when you say cherry pick, do you mean between court orders, between an anticipated court order, which I'm understanding this may very well not be, from Judge Hoffmeyer that may allow for employee carries, and the supervisory court order, which has, is that what you mean by cherry pick?
Over my head. All I can tell you is
all right.
this. All I can tell you, I'll simplify it even more.
Okay, gotcha.
All I can tell you is, those are the words he told me. I don't get a cherry pick.
Okay.
He's not here, I can't.
You don't get a cherry pick within that court order, what you follow and what you, okay, gotcha.
I mean, that's the same. I don't get to debate the judge when he comes out with an order, say, geez, Judge, I don't have that. That's what Miss O'Brien has. She's an attorney. So she gets to debate the judge. I just have to nod my head and go, okay. And as a good little foot soldier, I do what I'm told. You understand that. You're from the military. You give orders. And you've given orders, right?
It's Packel's time.
But I think I'm asking the same thing Pat asked you. If this passes tomorrow, an employee brings a firearm into the courthouse, are they going to get through courthouse security with that weapon on?
If they have a permit to carry, according to my attorney, that allows them. I just think it's a bad idea. I'm just going to tell you it's a bad idea. Workplace violence number 4.
Is that what you were trying to ask, Pat, when you said, how's this going to? Yeah, that's why I want just bottom line. Are you going to let them come in or not?
Because I want you folks to realize is that if this passes, that tomorrow morning, when an employee comes in here who has a license for a concealed carry, that they can bring a firearm into the courthouse. That is the reality.
But other people won't be allowed to.
And so I just wanted to clarify that to make sure that that is indeed what's going to take place. I haven't been able to, since the county attorney declared the conflict, I haven't been able to ask those questions, and I think you folks have. I think you folks have been talking to an attorney. Is that correct?
No.
No. Who has?
I would
I never go out of my way.
I got it too late to put on the agenda.
What do you mean, what you have in your hand?
What I have in my hand is a document that probably doesn't answer the questions that people are hoping for. It was one that I asked them the question. My questions are always, what can employees do? How do we go forward, whichever way things are decided? And there were a handful of questions that we asked the county attorney. As I said, asked our representation, and the response was given too late for me to be able to put it on the agenda. Oh, you can't hear it? The answers that I was given were sent back to me too late to put on the agenda.
The answers from whom?
From Heidman Law.
Okay.
And just a couple of basic questions. I don't think there's any real news here, and there's nothing revolutionary. No sides taken in it. It's, may the county amend the employee handbook how it did? It's just a simple question, and we're talking from a legal perspective, not whether it makes sense, not whether it's good, not whether it's bad. It's not for me to decide. The answer was yes. There is no rule or law that requires a political subdivision or county to prohibit its employees from lawfully carrying firearms. May the county prohibit its employees from unlawfully possessing firearms in the workplace? Yes. I think that's key. They cannot unlawfully possess weapons in the workplace. So in other words, if they don't have a permit to carry, they certainly can't come here with a weapon. So there were a couple of other questions. Please, sir.
May I ask a question of the chairman before we get into that too far down the road? Because I think the auditor's original question is, you folks have retained counsel. So this is news to me as far as this. And it's okay, I mean, but I want to know, because here's what's gone on a little bit. We've heard that the sheriff has retained counsel. I've heard the rumor that we've retained counsel, and you know, people get a little edgy, right? Because there's all this work.
Oh, absolutely.
And so I called the sheriff as one elected official, not speaking on behalf of the board, but I certainly have no disposition to want to be in some sort of public lawsuit or battle with the sheriff's office. Okay, so I wanted to kind of get that off the table. And my question to both our auditor and our sheriff was, what's your intention? Because I want to know that we can sort of, you know, work this out and have as much communication as is possible. So I just want to say this is news.
Brand new. Nobody has seen this but me.
On your own, you went out to counsel, or?
It was with the employee handbook. I was asking what questions, you know, from the handbook perspective, what we needed to do, those kind of things, that I made sure that we implemented whatever was going to be done with the employees in the proper manner.
When I ask on your own, I mean, did you pick up the phone and decide that on your own you were going to ask counsel questions, or did you do so in coordination with the chairman?
In coordination with the chairman.
Okay, that's fine.
I always end up crafting the questions in the conversation.
Got it. I just want to make sure that all of this is, you know, when it says you folks retained, and I've heard this, that's stated. So this is new information from counsel that you look to because the county attorney would not provide it because of that stated conflict of interest.
And yes.
Okay. Fine. I just wanted to make sure that we all knew what was going on.
I never asked you to reach out on that question.
This was this was a question that we had talked about. It may have gotten reworded slightly by the time it got to Heidman.
Okay,
that
well,
was a lot. You know, when you're in that conversation, you're trying to say this is what where the point of what the question we're trying to ask is, and so we did go there. I know they visited with the county attorney as well to make sure that they understood the question. I think anytime you're in those conversations, they're pretty fluid, and you come back possibly with a little bit different answer than, or come back with a question formed a little bit differently maybe than it started out.
Well, you had a fluid understanding then.
Yes, I would say a fluid understanding. That's fair. I mean, that's very fair. The idea was to try to get as much clarification as we could, and may the county may the county, while allowing lawful possession of firearms in the workplace, enact rules that prohibit any misconduct of such or misuse of such firearms. Clearly, the answer was yes to that. In other words, we can make a ruling, we can make it a policy that there is to be no misconduct in relation to those firearms, so that there is some, not necessarily restriction, but there is some expectation of behaviors.
And could you do the first question again?
Yes, may the county amend the employee handbook how it did? The answer was yes.
And what context?
There is no,
What do you mean how it will?
well,
The back of material, as stated, June 29, Mr. Gilliland sent out the email that due to the board action and the change in Iowa code, that the handbook would be changed. Once again, it's surprising to me that there's such a dense debate now when this was discussed at the last meeting, and there was absolutely no heartburn.
It wasn't a question about the policy. About the employee policy, there was not a question. That was not referred to.
And I'm not, again, I'm not in a position, I don't make decisions. I implement and I serve at the board's behest. So my point is never to make policy or to oppose policy. My point is just to be here to try to help figure out what we need to do with the employees. And
Is it fair to say that
Pat, would you mind taking the mic just because you know it?
Is it fair to say that the advice that you just received is in conflict with what the county attorney gave to us just in the email? About the ability, the process in which the policy was changed. Is that what you're telling me?
if you're looking for my opinion, I would say that and PJ, please help correct me where I'm wrong.
He's not going to, Ed.
He's not going to?
We're all on our own.
We're all on our own.
I haven't heard one.
Can I just have a rope? I'll just step off the bench now. I apologize, but what my memory of what PJ said is that, and I apologize, I didn't read this just before the board meeting. What my recollection of what it said is that the board had the authority to do this. Would there have been possibly a better way to have done it? Potentially. But it would have been to send out an advisory that we wanted to comply with the law is kind of how I remember it. But we're really going from memory.
Yeah, just to clarify the word policy, the policy was changed June 27th.
Yes, sir.
The handbook is a second order effect of the change in policy. There's not a policy in the handbook and then a policy in our policy book.
Can I?
Yes, sir. Please.
I don't like going off of this, what I remember, and that's
fair.
not your fault. I don't expect you to memorize emails, but if we could we have received some guidance from our county attorney on this particular question, not on the overall, but on this particular question. I think it's fair that the public hear that and hear what the answer was. Is that fair and amenable? Okay, so just be 1 second. It says, I want to recognize I do believe Pat to be correct, and the county has established a modus operandi on how it will affect change of substantive county policy, including those regarding the employee handbook. As such, the method used to address and announce the change to rule number 24 of the employee handbook via email without full board vote was contrary to that established procedure. What could have been done in the alternative was the issuance of a directive that effective immediately all county policies which appear to be in contradiction of the law, as set out in House File 517, including the prohibition against employees carrying weapons inside county buildings, are suspended pending further investigation or something along those similar lines. I believe this would have been well within compliance of established protocol, while at the same time allowing the county to address any legal concerns it might have for failure to abide by state law.
That's what I meant.
Second, I don't believe that there's a need to rescind the email that was previously sent addressing the issue. It's my understanding that an agenda item will go before the full board next week. Additionally, while I affirm it was not normal operating procedure, the board reserves the right to effect change via a majority vote regardless of any established procedure. My takeaway from that is it did not follow what the board has normally done in a change to policy. However, my understanding of that is it did not stretch to illegality, if that, is that, would you agree that that's a fair summation?
I just don't agree that it says that you did it, you could do it the way that you did it.
When you say you,
That's what Ed just read to you, is that it was okay for you to do it the way that you did it.
the way that the HR director sent out the email with,
If we're talking about specifically what I just read, it was may the county amend the handbook, how it did. And they're not talking about procedure. What this question was addressing is may the county address the handbook with, I think what the real question is, no. What the question is it's not procedural. Is this rule legitimate? Is this a rule that can be put into place? And I
With
think,
the full support of the board, or can the chairperson just send out?
and that's not what I'm addressing here.
That's what I'm trying to get to.
Yes. And that's not what I was addressing. I was addressing,
Okay, that's what the misunderstanding is.
is there, from a legal perspective, is there anything that would prevent that? Just
call in. Do we want to, they don't have it set up
Maybe
yet.
from a
Do
procedure.
we want to vote on this, or we want to wait 5?
Is it illegal to call the question?
Well, we'd have to, is there any other discussion, I guess?
There is, yes, I do have.
Okay, because.
Because I'm trying to get my questions answered so I can
No problem.
speak up.
My ride's outside. Do you think they'll have it up in 5 minutes, or should I just call Matthew?
Get the number from Karen for the conference line
Okay,
and call in.
all right.
Michelle can answer it.
they're trying to get the number down.
It's the same number. You don't know the number? Go ahead, Mr. Gill.
I'm sorry, this is frustrating to me too. I had no place to turn when I started reading these. I couldn't get the county attorney to answer the questions. I read through what it says here. It certainly appears to, and I agree with what Ed said in general. With the support of the board, you can, with 3 votes, you can do that. You can determine that policy. But what I heard PJ say before he recused it is that you have to take into consideration the entire law, and the law does say that. It provides for that you can do these sorts of things, and a court will decide if someone has been, what is it?
Adversely impacted or
Adversely
affected.
impacted. And he took both those, he said that you have to take both those into consideration. So I think that you can do that. And what I'm concerned with is, I wanted to find out is first what this means, because I don't know what it means. I haven't had those folks make that determination. I haven't been able to ask that question, exactly what this state law means. And what it's, it doesn't really matter as far as when you talk to a legislator, because once that law is passed and the governor signs it, it belongs to the people of the state of Iowa to make their own interpretations and to take it to court to do that sort of thing. But I haven't asked Dave, because I wanted to know what the practical impact is that if you pass this, and I want you folks to realize that if you pass this, employees can bring, if they're permitted to carry, they'll be able to bring it in tomorrow. Wish I could ask Rocky, as I saw you shaking your head, no, I don't know if that meant. what you agreed with there, but the.
Why, sorry,
Pardon?
I could ask a question.
Sure.
I don't understand why the sheriff would abide by that board vote, but not the one regarding the policy.
Because it's referred to in the order. That's what I was asking. It says this order does not affect the authority of county or city officials to determine appropriate employee policies for their employees in the county and city offices located in the courthouse and justice centers. So they've interpreted it to say that you can say that the employees can bring it in. That doesn't seem right to me. That's what the sheriff is saying. That's what they believe. And that's what, so I just wanted you folks to realize is that is what the impact is if you pass this, is that employees are going to be able to bring, they are going to let them bring firearms into the courthouse tomorrow if you pass this. And what I'm asking for, and I've talked to employees, and Dave's right, we're elected officials. We still control our purse strings, but we still, we're able to stand and talk to you. But those employees, they're intimidated. But what they've said to me, the few employees, not scientific, but a few employees said to me is, why would we let anybody bring guns in here when you have security there? There's no reason for it to be in here. I've talked to an employee who has a permit to carry, and the permit, and that person said, you know, if you're not letting anybody bring them in, I'm fine with that. But if you're going to allow people to bring firearms in, they're going to bring their firearm in. But so what I'm asking you is, because it came up, is that Ed made a good point when talking about secondary roads employees and employees that work outside the courthouse. You know, if you folks want to allow them to do that, you could do that. But according to what I just heard him read, is you can formulate that policy. But I don't know why you wouldn't say you can bring it to other places where you don't have the security, but in the courthouse where you have that security there, and there's no reason for it's a single point of entry, and it's covered, and there's no reason why I believe, and the employees that I've spoken to believe too, there's no reason for a person to have to bring a firearm into the courthouse if the security is there.
Mr. Radiger, you're present.
Yes.
We're hearing some background noise, so stop chewing on the Twix bar or whatever you're doing, please.
Thank you for the levity. My only question then, Pat, would be, would you say that that's a difference than across the street?
Pardon?
Would you say then that that's a difference across the street? Because if you're making the argument that why would you allow, if you have courthouse security, but there is a justification, certainly, it sounds like you're implying, right, if you don't have courthouse security that you would be allowed to. And we only have one building among the many buildings we have, and we do have many buildings, trust me, as the buildings and facilities. So where you don't, that is applicable and pertainable there too. And that's where I think the argument sometimes falls down, is that you folks have been arguing, well, where you do have courthouse security, well, that's one of all of our buildings. So would you argue conversely the opposite across the street where we have courts?
I would. Absolutely I would. You talked about whether it made sense to go to the parking lot or the streets or what. This makes sense. It's a single point of entry in this courthouse. And I believe that you should have it across the street where court is taking place.
The weapons ban. That's what,
no,
I'm not asking whether or not you want us to fund at Trosper Hoyt or at, I'm asking, you're making the argument that why would it be necessary for somebody to carry who's an employee, and what sort of adverse impact could there be? But the prime example that legislators Dawson and Winchell use, and even Judge Hoffmeyer, was when you are banning weapons and you do not have courthouse security, and the only thing that somebody has.
I'm agreeing that it's different.
Okay, so you're just saying for the Woodbury County Courthouse, but not
Yes,
Trosper
because
not the LAC?
I believe that you should have security across the street. I believe that you should have single point of entry across the street too, because that's the courthouse. I believe that you should be doing that. I don't believe it's the same as what you're doing here. I don't think that there's any reason why you should allow anybody other than law enforcement to bring a gun into the courthouse.
And would you say the same with District Health, the building in Nebraska, that there should be a prohibition against?
No, I'm not, because I don't believe that is courthouse. I don't believe that is where the courts are taking place. There is heightened amount of activity.
I don't disagree with you. I just want to make sure I understand the position is
I know.
to lift
Put myself out there like I don't care about those folks, but I do.
to lift the
Here's
weapons
advocacy
ban in
that
every
we do.
building except for the 3 would be the position, or the advocacy, just so I understand your position, would be to lift the weapons ban in all of the non-court buildings. So
I'm not advocating for that. What I'm advocating.
I just want to make sure I get a.
What I'm advocating for is that where it makes sense, where you have a single point of entry, is that firearms are not allowed into this building. Because it is. Disgruntled employees are a huge factor for workplace violence. That's what takes place. And I addressed what Supervisor Ong said earlier, is that we should have a rapid response team. I'm sorry, as I said before, that's too late. By the time that someone, and everybody's law-abiding until they decide they're not. And that's my concern. And it just does not make sense to me, or a number of the employees that I've talked to allow folks to bring firearms into this building when it's an efficient way of offering security for everybody, because you do. You have down here, you have where juries are gathered. And that's what the county attorney talked about, was that juror intimidation takes place, that sort of thing. This is the courthouse. This is where all those emotional things occur. And in the 20 years I've been here, it has spilled over into my office, because they don't like what they heard from some state office. They come to my office, and we have to rely on our wit to try to say, hey, you shouldn't do that. So that's my position. I wanted to make sure that the question is that you understood that what the sheriff is telling you is that if you allow this, and I would ask that you defer on it until you had time to get everything in line, because I certainly didn't have the ability to get a good understanding of what this all means put together. And I think it's a surprise to some of you that the sheriff is going to let those folks come in here tomorrow. So I'm asking you to go back to the drawing board and see what we can do on this. Thank you.
Any other comments?
Abigail, do I need to abstain on this? Thank you.
Was the answer yes?
Yes.
Oh.
No other comments from the board?
Well, I would be interested to know if there was anything else that legal counsel gave, as long as we were getting legal counsel, which I was unaware of. Or anything missing there, Ed?
And I apologize if I wasn't clear. I was just trying to find out from an employment law perspective what we could and couldn't do without violating the law. You know, and the other question I asked was, may the county prohibit its employees from lawfully possessing a firearm in the workplace? And the answer was yes, but by doing so, there's a risk of that an employee may sue the county pursuant to Iowa Code 72428, as amended by House File 517. So there was that piece. I mean, you can, again, you can do what you want, but the question is, do you risk getting sued, and do you stand in violation of the law? I tried to find out about other properties, how uniform do we have to handle every piece. things are allowed in one place and not the other, and they said you're really going down a rocky road if you try to have different rules in different buildings. It can be yes or no answer. So I didn't get a lot of solid advice. I just wanted to find out how we deal with the employees once things are put in place. How do we best, what other rules do we need to have if somebody's going to lawfully carry in the courthouse? Those kind of things, so that we're prepared, so that our employees aren't in a vulnerable position, and so that everybody knows what kind of conduct is expected. And I can go through as much detail or as little at this point as you like. I think I've covered the basics of it, but that would be your call.
Okay. I ask one other question. Thank you, Mr. Chair. This is not for you, Ed. Thank you. Thank you. Sheriff, you oversee courthouse security. How many employees have you had that have come through the metal detectors thus far and been carrying?
None.
Okay.
Because I put out a ban on top of that. It was like, oh, no, rock, paper, scissors. So I put out that there wouldn't be allowed until this court order came. But I want you to remember this last thing. The guy who was the writer of the bill, Dan Dawson, who I spoke with, said that counties such as Polk and Potawatomi don't have to change their gun ban because there's no adverse effect. Somebody can't come in and say, I'm adversely affected, because the sheriff and the county are providing security.
I agree with you, except I also agree with former legislator Gill, who understands that once you've put that into law, somebody who wrote that said, can add on, and then the other thing of there are places where we don't have that single point of entry.
Right.
So I get all that. I just wanted to see, you had sent out an email to all county employees, then Chairman Ung sent out an email to all county employees.
Right.
After the fact, and we have had no body right now, and they may be more fearful of you than Chairman Ung or vice versa. I don't know who's, but the idea right now is that since sending that out, we have not had one single employee of the 400 come through these doors and want to carry. Is that a correct statement?
Yeah, no one has.
Okay.
No one has.
And here's my 2 cents. I get it. If I was in favor of the law, I could have done something in the last 30 months. My biggest fear isn't David Gleiser, Ben Kuzler coming through the door and then somehow intimidating juries down here. I think that we are complying, and that's what I think that we are compelled to do. And I know that it's a bridge too far, but I just think in these 11, 12 days, it's...
Listen, I think that's a bad idea. Nothing against David.
Sorry, bad examples over there. Sorry.
Nothing against him, but I just think it's a bad idea that we have this, and that's why I think we should maintain what we have, because it's been successful. And just remember this, I really do believe this, and I'm far from being a lawyer. I didn't do well in constitutional law. So adverse effect, and what monetary damage would there be on adverse effect? I mean, really? I don't think. Injunctive relief is basically what we would be seeking from what I've talked to Mr. Gill and my attorney. Injunctive relief. Stop or you stop. I know PJ can't answer that, but that's my understanding of injunctive relief. Would that be right, Mr. Gill?
That's the question that I wanted to ask and still wasn't able to get from an attorney, but it appears to me from reading the law, it's injunctive or declaratory, which means it doesn't cost the county any money. It just says that you have to let them in. That's what injunctive and declaratory. That's not an attorney. But
go ahead, Ed, your turn.
There was one thing that got way over my head, and I know PJ has recused himself from it, but one of the quotes that I received back that I needed a little interpretation on was, I have no idea what injunctive relief for damages is. Declaratory relief is asking the courts to declare.
Mr. Chair?
Yes.
Who's talking right now?
I.
Okay, thank you.
Yes, I'm sorry.
No, it's all right.
No, I apologize.
I'm slow as it is, so keep going, Ed.
I'm not as clear as I should be, so My apologies. I have no idea what injunctive relief for damages is. Declaratory relief is asking the court, as Pat said, to declare something unlawful. Injunctive relief is asking the court to order that someone do or refrain from doing something. There's no such thing as injunctive relief for damages. That's the language of the new law.
We had a very lively meeting 2 weeks ago where this was debated. A lot of the same items were brought up. My closing remarks are the same as they are now. The debate's already been had. That's how the law was passed. Courts don't make laws. I understand the sheriff was not present for that due to being out of town and is coming here to say his piece, which he has a right to do. I also realize the personal investment having lobbied against the bill in Des Moines, but this is not something for all of us to take so personally. We all need to grow a little thicker skin and realize the debate here is, again, not about the substance or how we feel about this law. It's about rule of law versus Supreme Court overreach. That's all it is. The board's taken the opinion that the Chief Justice overreached. I can speak for the board because we acted in that way. So for someone, admittedly without a law degree, to come up and tell us what is and what are and are not the risks, there's no law degree to back that up. I mean, this is all hypothetical. What we are faced with, again, from our discussion 2 weeks ago, is whether we veered on the course of consistency that the legislature intended, which prioritizes lawful carry. Notice lawful carry. The operative word is law, that we're all sworn to uphold, including the sheriff. Or we go down the other road, which is seeking consistency in a complete ban on firearms in spaces connected to courtrooms. Sidewalks are also connected to areas connected to courtrooms, so are parking garages. We can take this as far as we want to, but at some point, you don't have to be a lawyer to read the Constitution and read courtroom. We have, Dennis is not a lawyer. You separate courthouse security from courtroom security in the budget for the same reason that the Iowa Constitution mentions courtrooms. The order to remove so-and-so from my courtroom is not up for interpretation. The person has a name. No matter how you feel about the person, law enforcement removes them. An order to remove something from an area over which you have no jurisdiction is up for interpretation. Obviously, from our district judge, from the board, from the sheriff, from our county attorney, or lack thereof. That's the reality. Yes.
I'd like to make one more. First of all, I'll go on record, I don't have an attorney for this. Okay. I never thought on this board I'd have to ask all the elected officials, bring your attorneys and we'll all have a meeting. But I mean, and you know where I stand, I don't want guns in the courthouse, period. I never have. I thought it's a bad idea because of what goes on here. But I'm even more concerned if this passes and tomorrow employees can bring them in, but citizens can't. I mean, that to me, that's, and I understand why we wouldn't allow citizens, because there's a court order putting law enforcement in the crosshairs per se, that you will not allow them in. And it's just, to me, it's just another problem we're going to have of, and would any employees do it? I don't know. But to even offer that to me is just bad policy until everything else is, and somebody's going to take it to court somewhere.
Just to clarify two things, when Mr. Potabom mentions we, he's not speaking for the board because the board took action contrary to what
I would
he
say,
just said.
I'm sorry, you're right. I should say I.
Yes, thank you.
I know I'm lonely over here.
You're a
but
sovereign elected official.
I don't mind that one.
Do whatever you want.
That's correct. But I don't have an attorney, so you go ahead and talk to me.
Secondly, to clear up the attorney thing, Human Resources has retained on an on-call sort of basis Heidman Law in regards to employment issues ongoing, which most recently included Sioux Rivers issues. This was not specifically asked by me or by any member of the board that I'm aware of to seek advice on this item on the agenda.
And that's absolutely true. That's absolutely correct. This was a.
Thank you. Thank you. That's, unless you have something else that's compelling to add.
Nothing compelling.
So to Pat Gill's question, has the board retained a lawyer? No, we have not.
You asked advice, he asked advice on the policy.
The only thing I would add to that is that I had asked for advice in regards to employment law and employment issues, and PJ had kind of deferred from that. Apologize. And so that's why I went to Hyde.
Right. And I was aware of that because Ed requested the motion the next day because he wanted to pass it on to the attorneys. That was in the question that he asked me.
Strictly in regard to employment law, though not
Mr. Taylor?
And look, I just wanted to get it out in the open because the big thing is this. There's no big smoking gun, I don't think, on the sheriff's part or our part, contrary to having legal advice from our county attorney for either one of us. I just wanted to make sure everybody's intentions were clear. This board is not on offense on anything as far as headed to court or otherwise. That was the first I'd heard of it, but I just think communication helps in all this.
It does.
To kind of deflate some of the.
Exactly.
So I just.
Very quickly, sorry to follow that up. This is why the item's on the agenda, to answer that concern.
Yeah.
Go ahead.
And Mr. Jennings sent us, I know you and I, a letter, and maybe the whole board wasn't a part of it, but.
No, unfortunately, I believe a memo was anticipated to the full board regarding not only the courthouse security issue 2 weeks ago, but also your item to follow.
Right.
Neither has been received by the full board, but I was aware of some of those answers.
So we were both advised that since he had a conflict, the board and the sheriff should seek their own council representative. That's what I did. I assumed that you guys did, because I had heard, there's, in this courthouse,
assumptions
there's
are
plenty of room.
Oh, there's no
assumptions
talk.
are dangerous.
So, I met with my attorney and.
I'm sorry, can we cover that in the next item? Mr. Gill?
I just, again, wanted to, because what Mr. Gillian said, I just wanted to clarify, is that the legal advice that you got says that they could indeed continue the employee policy the way that it is, but they do risk an injunctive relief or declaratory. That's what you said. Is that correct? Because what I'm hearing you folks say is that you have no choice, is because the law is what it is. And I believe both attorneys have told you that you can enact a policy that prevents them from bringing.
At the risk of a lawsuit, in which I know you'll say in the narrow, well, what punitive damages are there for injunctive or declaratory relief?
He just told you there.
But I think that's, hearing secondhand legal advice, I think there's also an argument that could be made if somebody is adversely impacted through other things that are not declarative, being assaulted, not having a right to defend, that there's a much larger liability question that can be made and be out there. So I just, on that one narrow thing, I think if the question is, what punitive damages are there for declarative relief, that's one thing.
There are lots of questions and lots of options, and I don't understand the hurry.
And to answer your question, I don't know that it says that. You can always violate something and take the chance.
No, I didn't say you were violating the law from what I remember you reading.
It says, may they prohibit the employees, and I was strictly talking about employment law and not the bigger picture. So can we prohibit employees? Yeah, but by doing so, you risk then being sued.
And we're all well aware of that, but they said that you could do that. And it doesn't say that it's illegal to do so.
I'll leave that to you guys' interpretation as elected officials. I don't think I'll step on that, but it just says that by doing so, there's a risk that an employee may sue the county.
Don't we stand the risk of getting sued? Exactly.
Not bargaining.
No, I understand, sir.
Yes is the answer.
Yeah. We get sued all the time.
Okay.
But very few times does Iowa code spell out if you make so much as a motion, an ordinance, or anything. Here is the way to do it. I mean, that's a pretty express intent. That's just
the
my
bar is as low as a motion. Mr. Raddick, are you present?
Yes.
Hearing no
Can you
other-
hear me?
Yes, we can.
Okay. All right.
Hearing no other comments? Mr. Gleiser?
I'm sorry, I'm just intrigued now. With this policy, does it matter if it's a non-professional permit or a professional permit? That would be.
It has to be lawful.
Yeah, it's either one.
Will the auditor please call the roll?
Did someone make a motion?
Yes, the beginning of the item. Motion by myself, second by Raddick.
So long ago, I forgot.
Yes, I know.
DeWitt. I declare a conflict.
You have to say you declare.
Audubon.
Thank you.
No.
Raddick.
Yes.
Taylor.
Yes.
Aye. The motion passes 3-1. Potabom opposed. DeWitt abstaining due to a conflict of interest. We move on to item 12, an action item from the County Sheriff, Dave Drew. This is a request to hire outside legal representation, Doug Phillips, Class Law Firm, LLC. May I start out with a question? We've had some back and forth emails between us and the county attorney when this might have actually happened. So can I just ask you, when did you retain? I got an email from you on the 6th.
Of July?
Yes. When did you actually retain Doug Phillips?
The day after the board meeting,
The day after the board meeting.
which, just a minute, it's been a couple weeks, so I believe the 28th or 29th, right in there, of June. Because I think that's when Mr. Jennings' email came out, somewhere around.
He's had several emails. Which email are you referring to?
I got one, well, give me a minute. I got- Yeah, of course, I don't have the one I want, but he's had emails that have gone back and forth. I think it was, I have one that, I think I told you I've retained Doug Phillips as my legal counsel to represent me in the courthouse security issue. And I think PJ sent one out also. That funding be retroactive June 29th if necessary. That day represents the day I actually declared a conflict.
Is there any reason why you notified me or the board that you retained an attorney on the 6th when you actually did on the 28th?
I don't know that it was necessary because I know we've been discussing that there was a conflict. I can get an attorney probably at any time. If you're concerned about when you're going to pay it, you're going to pay it one way or the other. I mean, that's not the debate, I hope. You're going to end up paying it, and you're going to pay it out of liability fund. So that's the practice. Doesn't come out of my budget. If you're going to have it come out of my budget, then expect a budget amendment in May.
Well, it's again, we're in and this is no personal affront to our county attorney, but we're in waters where we've kind of been given half an answer on this.
Well,
he declared a conflict of interest, but has advised there's no absolute right to outside legal counsel.
Boy, I didn't read that.
Well,
His letter says there's no right to outside legal counsel. I don't think so. No.
What I believe I stated, that there is no absolute right.
That's what I said.
But each elected official or department head has a right to request it, and if the board chooses to say no, they have an avenue where they can challenge that refusal to attorney fees. And then what I added was, it is doubtful, no, let me rephrase that. It is probably within the board's best interest to say yes, because that would be in the best interest of the taxpayers. That's what I believe I stated.
Yes.
Can I ask a couple questions as a sheriff? Sorry to make you go back and forth. I'm doing the naturally slim.
Part of his wellness program.
So one of the biggest things that, and I asked this of auditor and I asked this of you, and I think it's a fair question of the board, right? If you had two neighbors and you found out either one was retaining legal counsel, you'd want to sit down and have a cup of coffee and say, hey, what are we doing, right?
Right.
So my question for you is, in retaining legal counsel, what are the intentions? And from our phone conversation, if I may, you said that it wasn't to end up in some sort of high-profile, deal. And I told you, as far as I knew at that time, we hadn't retained any sort of counsel. I was unaware that a question had been asked. But is it fair to say that you're asking for some advice as it relates to supervisory court order or a chief judicial judge's order that follows on, or some
I'm looking
things?
for clarification for the courts to decide who's right, and with nothing punitive, just merely who's right here. Make a decision, please, if you can, to say the sheriff can continue the ban, or no, sheriff, you can't. At the end of the day, I'll buy you coffee if you're...
I like 2 cream and 1.
How is that different from like a redundant order? I mean, we had a 5-page supervisory order that we all read. If you're going to ask for further clarification, can you, I mean, I think we both agree that it would be helpful if a case was brought and there was an actual ruling, because you've referred in, your letter to me on June 27th, an opinion and an order.
Right.
I don't know if you mean the opinion to be a ruling. I still don't think that there's been a case hasn't been litigated. There has not been a ruling. There's been an order. Are you asking for an order, about an order, or a second order that says the same thing? Or I don't know how you can get higher than the Iowa Supreme Court if you're asking for expert legal.
So the Supreme Court interpreted didn't really interpret. The law hasn't been in effect, okay? The law didn't get into effect till July 1st. So my limited knowledge of the Supreme Court is they can't rule on anything till after the law becomes in effect.
Right.
But they can put out orders, just as Judge Hoffmeyer can and any judge, and direct the sheriff on how to proceed. So I follow that order. So what I'm going to assume that my attorney will write up is to seek injunctive relief or declaratory relief. I'm learning new words every day. And so they're just merely going to say, Sheriff, you're wrong. Okay, I'm wrong. So I'll come back and say, I guess I was wrong. I'm not going to apologize. Felt like I was right. And I don't expect you to apologize. You think you're right. So we're at an impasse. It's no different than a lawsuit. I mean, a lawsuit is 2 parties can't come to an agreement. Don't mean they have to be enemies. They don't agree with this. You and I, we can't go out in the back alley and try to decide who's going to win this. It's just not possible. And I'm not going to convince you until the cows come home that I'm right, and you're not going to convince me you're right. So there we are.
From part of an answer we received on from our county attorney, as far as this agenda item, received by myself and the vice chair, and sent to you, I believe. If not, then I'm not aware of that. I'm going to quote an excerpt as to why the board would, why you would seek board approval for something you already did. So, quote, "The argument then becomes, was it unreasonable for the sheriff to have thought that he was put in an untenable situation of deciding whether to follow the board's directive or the Supreme Court order prompting him to seek the immediate assistance of outside counsel, ? End quote. My simple question to you is that how you felt?
Yeah, we just couldn't, I mean, you're going to have a ruling, I'm going to have a ruling, and yeah, so we're going to have to.
Okay, so you felt that you were put in that untenable situation of deciding, and you were unsure of whether to follow, so you thought the next day you need to get an attorney, is that correct?
I needed an attorney.
Okay, so the picture you're painting with your answers is that you were unsure, you asked an attorney, you're in this untenable situation, you weren't sure whether to follow the board's directive or the Supreme Court order, but with all due respect, the picture that you painted before the board adjourned the meeting a day before was to say, of course, without context, that the board has politicized this to protect their own political capital. Right. I still don't know if you know what political capital is, because as you can see, we haven't gained any favors from this. This has not shored up any votes. This is something that was unpopular. And then, the picture also becomes, I'd rather be held in contempt of the board than the Supreme Court, right, which was a great zinger. I have to give you that.
Thanks.
You're welcome. And I think you put that on Facebook too. We're dealing with two pictures here. We're dealing with the picture of, you say that you were put in an untenable situation, you weren't sure which direction to go, but the picture that we saw was that you sent a letter right after the board voted and said, you're going to do it this way, this is your order, you're sure of it, and you're going to continue the ban. So, I mean, to me, your mind was already made up.
Right, it was. It still is.
So,
but I have to have an attorney.
You do?
Your mind was made up. Sure.
Your mind was made up already, and you're telling me that you retained an attorney because you were put in an untenable situation and you had to decide whether or not to follow the board's directive or the Supreme Court order. My point is you already decided.
I will step in because those words, respectfully, are not Drew's words. Those are my thoughts.
Right, and I posed that question to him. I said it was your words.
But I would add, though, that I also believe, and I didn't put in those comments because I didn't want to, but that the board actually put him in a position where he probably needed to seek it, because the statements by the board, and I don't know who made it, was that if you're going to sue, if the public's going to sue him, not us. Somebody on the...
Yeah, but I want to be quoted correctly, and I know you're paraphrasing. I didn't say sue him. I said, I did not say sue the sheriff. I said, and I'll quote exactly what I said, the standing would not be against the Board of Supervisors. In other words, we have done everything that we have to do in order to follow the law.
Right. You said sue the sheriff, not you.
I didn't say sue the sheriff, but I said, yeah.
I felt kind of alone.
Right.
Just want to know that
yeah.
I didn't have a paddle. I didn't have a paddle on that one.
Right. So, but I mean, the phraseology is important to me. How's that? So, here's my question, if I can move us. Can I?
Unless you wanted to respond or say that.
No, I took it as it was all now on the sheriff.
Right. I believed, yeah, and I wasn't trying to throw you overboard necessarily. Right. But my point was, I believe that the board had done everything within its power to comply with the law. And I trust me, I get the philosophical divide. No problem there. I guess my question is, since we're on this particular point, and I don't want to get distracted from it, that's really what this agenda item 12 is about. Up until this point, when you say injunctive relief, declaratory, is that the right term?
Declaratory.
Is that seeking Is that a court date with the Board of Supervisors and dealing with that, or?
I would assume so.
Okay.
That would be an attorney question. I'm sure that somehow this gets a court date.
Okay.
And we have to decide who's right.
Okay. And I just wanted to ask that because in our conversation we talked about, I was just looking to see, are you looking for advice here or there on finer points of the law and this or that? Or are we headed to some sort of, and I had assured you that on our end, I had never heard of doing anything other than trying to get the legal advice that we normally
Right.
get.
And I think that's all we're going to get, but somehow that has to end up by a judge hearing it.
Okay.
So I guess his question, not to put words in your mouth, but, you know, if there's no case right now, what's the end goal? Is it suing the board? Is it suing me?
I don't
Is
know.
it suing, what, you just want another opinion?
It's exactly this. It was hard for me to get, but Mr. Gill has beat it into my head enough, and we talked, and my attorney, it's not that we're going after each other. Please get, that I think is what you're misunderstanding. It is that we're seeking that injunctive relief or declarative relief to let the courts decide who's right in this. If you're right, you're right. But I'm standing on my principles as you are standing on yours.
I just don't know how that's going to happen without a case.
You will have a case.
Okay.
You will go to court, and the Heidman Law Firm will represent you. That's my understanding, just as Mr.
So it would be to sue the board.
I get what you're saying.
If you're asking for declarative relief, it's really not a lawsuit. It's more like we've reached an impasse. We're asking the courts to be the arbiter.
Okay.
Okay.
That gets asked not every day, but quite often in courts.
I do want to say that one of the questions that came out of that was answered was about this very issue that we just dealt with, is on the policy, is because that was when that question came up, and that's what he asked his attorney was, what does that mean as far as the employees, what you folks are going to do? And that was a question that he asked his attorney, and that's how he related to me, is that if an employee, if you pass that proposed update to the handbook, that's a policy change, and how is he going to interpret that? And his attorney told him that you can't cherry pick it. Right. That was part of the reason why he asked for to get advice from an attorney when the county attorney couldn't do it, and it was necessary to happen right away.
I mean, you asked me about this political capital and all these things. I'm hesitant to get into it because I want to keep it above ground. I think I have a good basis, but I just don't like to keep getting pushed on that issue.
Fair enough.
If I could, to go to the item on it, I would make a motion that we allow Sheriff Drew to hire outside legal representation.
Is there a second to the motion? Mr. DeWitt?
Can you state the reason for that?
Because I'm a sheriff's office employee as well.
Are you a lawyer? Could you at least make yourself useful?
But no, I am not.
Going once? Sorry, what? Going twice? Motion fails for lack of a second. Mr. Radiger, you present?
Yes.
Could I ask, in your time with the city council, there was some litigation involving wastewater treatment plant employees, correct?
Correct.
Can you describe what basis there was for the city council to deny legal representation to those employees?
There was any time where an employee was away opposite.
Could you speak into the microphone, please?
I think I am, but it's just hard to pick it up in the car. Anytime an employee acted in a way that was not in accordance with the way the council decided, they would have been denied legal representation. I did have a couple questions. Also, what was spent so far and what was anticipated to be spent
First of all, I'm not an employee, I'm an elected official, so let's get that straight, okay? This is getting very silly. You want to vote no, that's fine, you'll pay for it. Are we done? Do you want to keep going?
Yeah,
Seriously?
I do, and I'm not
This is
rubbing.
unbelievable.
Stay.
Elected like I am. Transparency? How'd that call just happen to come up?
What call?
You guys just talk about that conversation. Is that some conversation you had before? Asking me about legal representation? You asked Mr. Raddick, how can the water guys get lawyers?
Yeah, Mr. Raddick and I talked about that. I can talk to another supervisor.
Yeah, you can.
So
I don't know what's improper about that.
Frustrating.
Sheriff, if I can ask you, I'm of the opinion that you're due some legal representation,
Absolutely.
and that one way or another, if I'm understanding from our county attorney, we're probably going to pay for it one way or another. I didn't understand at the very beginning that we were maybe headed to injunctive relief or whatever it is. But I do think you're entitled to some representation. Just like our board is entitled to theirs. So I don't know exactly how to frame that. What I didn't want to do, and what I don't like about this whole thing, and I don't like spending taxpayer money. I don't think you like spending taxpayer money. We have 2 outside legal counsels, okay? So that's my rub. So I don't know how to get beyond that, except to say, I don't know if there's some sort of limitation or something that makes it seem reasonable, or if it's just open-ended and we end up approving a claim retroactively.
Well, first of all, could you address Raddick's question on how much has already been spent, if anything?
No idea.
Okay.
No attorney's going to bill you before. We haven't really had anything.
So is it reasonable to make a motion up to a certain amount, or is that a bunch of...
What if it exceeds that amount?
Then you'd have to come back like anything else. I don't know. All I know is I'm not comfortable with, this board can have outside legal representation, but another party cannot, because I think that what I'm trying to say, Dave, is we obviously in this instance used outside legal counsel.
You did.
Right. Not me, but yeah, I get it. And I think that you're entitled to the same in some instance. So
Exactly. I'm not sure why we're not approving it.
that's what I'm trying.
Have something to say?
That's why I'm trying to get there exactly how that works.
Trying to be patient.
I know you are.
The only thing I want to say is the outside counsel pieces we were talking about was strictly employment law, and we weren't trying to figure out House File 517 or that type of thing. It was strictly how we do it.
Right, but the sheriff has the same kind of questions that we have, and to say, well, you're not going to be able to ask the county attorney, but we can ask outside legal counsel, sorry, isn't fair. I'm just going to call it. I mean, you can't say that the HR director can do that. He can't call the county attorney. And so what recourse does he have but to rely on his own wits? And you and I both agree that that's not good for either one of us in this legal instance.
Well, the advice that may have been received on an employee law or regulation that was outside of the scope of House File 517 is for the good of the whole county. It's not as if we receive something and it's automatically in opposition to another stance. It's simply in relation to the employee handbook and whether or not it can be updated to comport with law. There was no call from me to Ed to say, contact an attorney, we need to go, to injunctive relief with the sheriff.
There was no reference to anything, and I just used it as a way to try to talk about employee handbook and what we can do with employees.
I guess my point is you did.
And I'm elected.
All right.
I have my own policy. I don't follow your policy. I've told you that before. We do not follow the board's policy. We follow the policy of the office of sheriff. that's the policy that we have.
If I could, Mr. Chair,
Yes.
the one thing, and I'm still learning this county stuff, trust me, and I spent time on the city council too, and I was involved in litigation over there also. But I am learning that elected officials are not water plant employees. They're your sheriff is an elected official, which is not our employee. Exactly. That makes it a little different in employment law when you're dealing with elected officials. And I, again, don't have a law degree, don't want to, was told once I couldn't practice law without it anyway. But I don't see, and if you want to set a dollar amount or something, to me that's nitpicking, but I don't see how we could even try to deny him the right to seek outside counsel on this issue. Legally, I don't think we can deny it because you're an elected official.
You believe your statutory duties lie with this supervisory order?
Correct. And
the board believes your duties lie, your statutory obligation lies with the code.
The majority.
So, the majority of the board, yes. The board majority acting for the county, affecting policy. There's an impasse. Yes, there's an impasse. I'm troubled by the fact that I know the sheriff reaches his own conclusions without legal counsel and sticks by it.
35 years of practice and experience tell me that I follow orders from the court. It's been a good practice. It's kept me from having any issues with the court. As an elected official, I think I'm on really solid ground.
That's fine.
So what's the point? The point is, I need an attorney. You should provide it. And that's the end of it. And we'll find out what happens.
If it's a right, I don't see why you need our approval. I mean, I know that you do, but...
Well, exactly. I mean, it's when you want decorum and you want to follow the parliamentarian rules of all that you have, then I should. But if you don't want to, that's, at the end of the day, I'm going to get it. It'll come out of my budget. I'll pay for it. It's better to come out of the liability fund if you're really concerned about taxpayers' money. You set aside liability dollars for these types of issues, lawsuits that come up. So why not use that money that's already set aside, then shorten me to pay for an attorney, if you're really wanting to be frugal with the people's money.
I'm going to weigh in there just as far as the process and what has occurred. I think Mr. Radig he's not an attorney, and I don't think he gave you good advice on this, is that my understanding of what occurred with those city employees is they violated the law. They knew they violated the law. When it comes to approving claims, this is what would occur, is that Sheriff Drew would submit a claim to pay for that legal counsel. And the only ability you have to say no to that is if you think he did something illegal. That's the way it's been. If you think that he acted with being outside of the scope of his duties, that's when you can deny that. And I'll leave that up to you to determine that. But that's what the difference is between the legal advice that Supervisor Radig gave you, is that those folks were violating the law. And I have a little bit of experience with this. When I was told originally I wasn't going to get legal counsel, and then it turned around that they were to provide it. I was acting within the scope of my duties.
And so in that,
But the board's position is that the sheriff is acting outside of the law.
You better get some legal advice.
First of all,
Name and address, please.
Teresa O'Brien, 3444 Jackson Street. Your position is that he's acting outside the law, but our Supreme Court Justice, and I am a lawyer, by the way, said that he told him to do something, and he's doing it. As a citizen of Woodbury County, I want to know if Sheriff Drew's right or if you guys are right. You didn't even have the guts to take a vote. I mean, You didn't, nobody would even second it to take a vote. You guys sat up there to be quiet so that it's not reported how you're going to vote. Somebody second Mr. Potabom's motion and decide whether or not you're going to give him legal advice. You can't say that, Mr. Taylor. Oh, I think you should have it, but you didn't second it. No, you didn't second it. You know, I believe that the Constitution outweighs anything that the legislature brings into effect. And Justice Cady, not Mark Cady, Justice Cady, and he deserves your respect whether you think so or not. Justice Cady made his ruling based on the Constitution. And Sheriff Drew has every right to think that Justice Cady is wrong because he's not a lawyer and neither are you. So until some judge somewhere tells you that Justice Cady is wrong, I don't think you have a right to question our sheriff. I think he needs to know who he's supposed to follow. And for you not to give him money is ridiculous, especially, and don't tell me that you don't have somebody go into the Heidman law firm. That's not right. You guys need to give, we elected him, just like we elected you. Well, not me, but a lot of people.
I was going to say.
Elected Mr. Potabom. Anyway, my point, it doesn't matter whether I like it or not. I don't like the way you're treating Justice Cady, and I don't like the way you're treating our sheriff. Give him the respect that you would like to get. Give him the money to find out if he's doing his job or not. I think everybody in Woodbury County wants that. That's not even what I came here for tonight, but I'm getting madder by the minute. Thank you.
When a suit is filed, we'll cross that bridge when we come to it.
That's stupid. That's way more expensive to do it that way. Way more expensive to do it that way. Trust me, I know.
I second her.
Well, if I may.
Yes.
I was trying to get to some parameters and clarity on the issue. You may or not believe that, but that's where I'm trying to make sure I know exactly what it is that I'm voting on and where it's coming from. I do believe the sheriff is entitled to legal representation, and I believe that it should come out of the liability fund. I would like to put some sort of limit on it. I don't think that's unreasonable for taxpayers. Call me crazy, call me backwoods, whatever. So I would move to put a cap of $10,000 from the liability fund, and if there's something in excess of that, to come back to the board. I don't think that's unreasonable. I do believe you're entitled to representation, just as I believe that we, in this instance, have used representation. And I don't think if at that point this needs to continue, I don't see denying it, because I do believe that you are doing what you believe is in your duties. I don't believe it's a good example of two city employees, but that's another deal. So that would be my motion. And furthermore, I haven't made that motion yet. I would question whether or not there's an abstention that's merited in this instance by Supervisor DeWitt. So I'd ask that to be reconsidered. How is, and I would ask our county attorney, how is an employee in this instance, because you have an attorney that is married to an employee in the sheriff's office, that's the legal counsel, is it not? Is Doug Phillips not? If that's not going to be declared a conflict, I mean, we're sort of stretching this conflict of interest thing to mean a certain supervisor can't weigh in because he's from the sheriff's office. I mean, if that's the case, I don't see how you vote on a budget or do much of anything. So,
I would just add, and I appreciate the question, as it applies to this specific issue, whether he can hire an outside counsel or not, it's my opinion that he would not be conflicted. However, whether he's conflicted or not is his judgment call. We can't make that call for him. That's personal. If he thinks that he's conflicted, right or wrong, that's his choice. I personally don't believe he is on this particular issue. But again,
and I would just ask respectfully, and to for Supervisor DeWitt to reconsider.
And I would say that I would just ask the board, as a matter of decorum and cooperation, that he is an elected official. We heard the argument before that why do something only to wait until we get sued, but now I'm hearing that argument in the reverse as to why not allow him funding for an outside counsel. Again, I don't want to get into all the heated personal issues because that's the only place it can go, but I would just ask the board, because ultimately I believe he would be entitled to representation. And so that would only lead us to fighting one lawsuit just to get to the next lawsuit. And again, that's not in the best interest of the taxpayers or this board, which is what I've already previously stated.
With all due respect to that, Gail, since PJ is your boss, I'm going to go with his opinion. And this still absolves me from getting yelled at, though, right?
So in that instance, I would make a motion to approve up to $10,000 from the liability fund in order to seek legal representation for the sheriff. And I'll make a comment after.
I'll second that.
And my only comment for discussion would be, just like you and everybody else, trying to look out for taxpayers in the sense, and I don't think that that's an, I've said probably not.
Right, no, I agree.
Mr. DeWitt, any comments? Any other comments?
I ask that the auditor call the roll. There's a look in his eye.
Yes, please call the roll. Any member can ask for a roll call vote.
Chairperson declares the debate. DeWitt. Aye. Potabom.
Aye.
Radig.
No.
Taylor.
Aye.
Oh.
Aye. Motion passes 4-1.
Thanks. So just, could we have a gentleman's agreement, 10,000 each?
If you go above it, we know you'll tell us later. Item 13 from Board of Supervisors, Jeremy Taylor's information regarding Sioux River's funding of Sanford Center and supervisor inquiry.
Thank you very much, Mr. Chair. I just wanted to pass along an email in the spirit of transparency on, I was not at the last Sioux Rivers region meeting due to coming off of military training at that time, but just wanted to raise a concern. I had sent Shane Walter, the CEO of the region, an email just questioning an approval to an MOU with the Sioux City School District regarding Sanford Center funding, and just wanted to see how that comported to the original intent of the mental health levy. You have the information in front of you, and just looking for answers to questions. And so there we go.
You anticipate answers in a certain time frame?
Mr. Walter did get back to me today. He let me know that Patty might be able to provide some further clarity. Also reached out and have asked questions of the schools just to see kind of the history of this. I wasn't there for the meeting, but we had not been told that juveniles were necessarily served by these dollars, specifically in the past, outside of potentially this exception, and just wondered how that worked. So,
yes.
My name is Patty Erickson-Putman. I am a Woodbury County employee and work with as the Sioux River Service Coordinator for Woodbury County. History, I'll try to make it as quick as what I can because you've really been through the mill tonight. Safe Schools, Healthy Students started as a federal grant back in 2003 approximately. federally funded for a 3-year time period minimally. As they were slow in getting the program started, that money kept stretching out, okay? 2005 was the first time it was discussed as being paid for out of the mental health fund. As a possibility, it wasn't until 2009 that that actually occurred, because DHS said, I believe it was in 2007, that if we had a child that went to a mental health center, we would have to pay for those services, okay? So that all evolved there. But the federal funding, they required local funds to replace at the end of that. They came to the county for those local funds. We were able to do it. It was approved through DHS at that time. Through our action plans, I've got quite a few documents here that I was actually able to find going back to 2005. The Safe Schools, Healthy Students was put into effect for a multitude of different programs. The therapy and the outreach workers were the only two components of all those programs that were found to be long-term positive impact on children's lives. That was documented by Dr. Cuny and Karen Mullen, who's also a PhD, and they did that through the Briarcliff University, the Siouxland Social Science Research Center. I didn't make you a copy of this, but this is it. It was a 3-year, it's evidence-based, and it does all the reporting on all the statistics. The outreach workers, some of your question in number 2 was what's the role of the outreach workers? They are the first line of defense. They work with those kids immediately, and they receive referrals. It's not like they just hang in the hallways and wait for a kid to misbehave. There are referrals that come to our outreach workers from teachers, parents, administrators that ask those outreach workers to get involved with those children. They are assessed, evaluated, and then referred on for additional mental health services if that's felt what is necessary. Okay, you asked about the education of the mental health workers out there.
I'm sorry, may I ask you something? You said mental health workers. Are you saying
the outreach workers. Okay. And I have copies of all this information for all of you, okay? You have BAs in sociology, criminal justice in Spanish, BA in English and Language Arts, criminal justice. You have one high school graduate who is working towards his associate degree. You have a BA in developmental psychology and mass communications. You have a Associate of Arts in Child Development Certificate, Head Start, currently working towards Associate in Behavioral Sciences. You have a gentleman that has coaching and referee certificates, and that's all he's working towards his AA. You have one gentleman that is general education. You have another associate degree with English as a second language and a vet assistant. You also have an MA in behavioral disabilities.
How many of them are licensed mental health practitioners?
And what do you mean by none of our?
The outreach specialists.
Is this program different than others?
What do you mean?
Is that what you're expecting? Is licensure? Or just
no, I'm just asking, or how many of them have mental health diagnosis capabilities or background?
There's only a master's degree in psychology that can do diagnosis.
Okay, so none of them?
They have also 3 to 27 years of experience in working with emotionally and mentally disabled or affected young people. So, I'm not understanding, Mr. Taylor, what your question is.
So here's my thing.
I'm not a licensed medical.
Okay, or a mental health background.
But I have 30.
I think a lot of the public knew there was $186,925 going to the Sanford Center previously to this board taking action as of 2 years ago. I don't know that the public knew there was $200,000 that was being routed through the Sioux City Community School District with an MOU for 5 full-time equivalents through the mental health levy.
I would beg to differ with you on that. Funding of that program was always discussed at our mental health public hearing, and it was identified as a priority to continue those work.
The CEO of the region was surprised. Even though this was in the background materials, our budget analyst was surprised. If they don't have that level of granularity, I would say that the general public, if you asked out there, did you know that in addition to the $186,925 that the Sanford Center was getting, that the Sanford Center was getting $200,000 from the mental health levy, that would be a surprise? We may disagree.
It was brought before the Board of Supervisors every year from 2009 to 2014. It was included in every one of our mental health public hearings. I've got the minutes of those hearings here.
Right, but
that prioritization in our mental health hearings had anywhere from 30 to 50 people in attendance.
Sure, but that Board of Supervisors changed drastically in the election of 2014, and
in 2014, we had to change to the region, so it went to the regional funding.
All right. I'm just making the point that the CEO of the region seems surprised, even though this is all clearly laid out in the background.
Shane was surprised?
Yes, he was. Absolutely.
I
and Shane can weigh in on that.
Those two programs, our outreach workers and our summer school for disabled children, were written into that specific legislation because they did not want Woodbury County to lose those STAR programs. We have since repeated and set up components of the Safe Schools Healthy Student Program in Plymouth and Sioux County and put therapists in their schools. They don't have the outreach workers yet because they aren't to the magnitude, the size of the school districts that the Sioux City Community School District is. So, and Shane signed the agreement.
Right, which is why I was surprised that he was surprised.
Sorry, Mr. Raddick, you were going to say something?
Yes, I wanted to bring up that when we voted on the budget at the region, nowhere did it have specific line items saying where funding was going. And when I did request specifically what partners and organizations we partner with and how much funds they get, I still have yet to receive a response.
Yes.
Our budget analyst seems surprised, or CEO seems surprised, and again, egg on my face for not being there or coming off of military duty, but it says $200,000, 5 FTEs, Sanford Center, project budget. Location of personnel to be determined by the Sioux City Community School District and Sanford Center. Mm-hmm. Then there's $260,600. I'm sorry. Then there's also Siouxland Mental Health, which is the other component of it. My question is, we talk about outreach specialists who do some great work, and I know because I've been in the schools, and they do great things. Nobody denies that. But somebody who's a high school graduate, coaching and refereeing, criminal justice, Spanish, to use the mental health levy to the tune of $200,000, I don't know comports with the original intent of the mental health levy, especially when they're not either doing diagnosis, therapy, treatment. I get that they have the stretch of 3 to 27 years of working with kids, and
we need to talk, because if you think there's anybody out there in all of our programs that have the ability to diagnose, you need to see our system. We don't have people other than at the actual Siouxland Mental Health Center, Creative Living, Plains Area Mental Health Center, where you have diagnosticians that can actually diagnose and prescribe medication. The frontline people that we have working in all of our residential programs, vocational programs, programs such as this, they take special people, but I would say 75% of them are not degreed in anything.
But I guess my entire point
and
is...
they are referring children on to where they
sure,
need to be.
Absolutely, whether they have mental health issues or not. Would you agree? Not every single one of...
they have emotional, behavioral,
sure,
or mental health needs.
Yep.
And I've got all of the documentation here for you.
But that's my point, and that's why I believe Shane said, I'm not the only one that's been raising this since that meeting, is that to use the mental health levy on outreach specialists that may come across a variety of issues and may include a mental health issue here or there and don't have the licensure, background, or anything along those lines necessarily. A high school graduate to me doesn't necessarily speak to that, may or may not, but I think may not seem to comport with what the original intent of the mental health levy was for.
If you had that degree of capability with every one of the programs that we have, your budget would be 5 times at least what it is. Our frontline workers are people. They're not licensed or certified individuals.
And may or may not have a mental health background.
No.
See,
It takes a
that's
special-
shocking
it
to
takes a-
me.
It shouldn't be. If
but
you
that-
want to tour our programs and see our people and meet our people, hey, I'll take you anytime, any place.
So-
These programs are not run by clinicians, they're not run by physicians.
So no mental health background or training. Refereeing, coaching, high school graduate, and we're using mental health funds to the Sanford Center. Sure, I get that there's a whole range.
There's a whole range.
It just doesn't seem to,
Did you ask Mr. Walters what his degree is in?
I did not.
You need to.
And maybe I'll have further following questions for him as well. But my point here is that when we're paying for something that the legislature set up specifically for mental health purposes, that it seems that this may be a doubtful use of funds, and that the Sanford Center.
If that's the case, then you have to compare that to every other program that the Sioux Rivers funds, because the employees in any other program is not different than what is available through the Sanford Center. In fact, I'm very impressed with their level of educational qualifications and interaction with the youth.
I'm impressed with their interaction with the youth. I've seen them as well. I just don't know if it's the greatest use of the mental health levy in order to fund something that federal funding went away for. And then during a time that the tax money of general basic and otherwise was being expended to the Sanford Center, I just think the public would be interested to learn.
I believe that was to a different program. I had no involvement with that $180,000.
Right. No, and I agree.
This
That
is
was
only for the emotional, behavioral, and mental health needs of children in our schools. That mental health issues start at age 11. And they continue to receive training in mental health first aid for youth, in behavioral problems, behavioral modification. They continue to receive that specific training, as well as their on-the-job experience. And it's no more, no less than any one of the other workers that we have in any other program. Like I say, I'm very impressed with their level of education. For that percentage of those folks to have that level of education is really, really impressive for me.
I don't know if you can answer this, Patty, so it's probably more of a rhetorical question. How can Shane, the CEO, how can he be surprised about this?
He signed the contract yesterday in our office.
Right, so
It was
I'm
voted
asking.
on at the June 28th meeting or whatever. It passed. Mr. Raddick seconded the motion to sign the contract, approve the contract. Shane signed the contract yesterday in our office at a staff meeting. So I'm surprised too. I don't know. But I do want to leave you all with this information because I think there's a lot of people who don't get it and don't understand. I think what's being done out there and for our kids, and to know, and here's the part of I know we've had issues over the mental health funds being used for juveniles. This is the legislation as was written in Chapter 331 that said specifically, the only way you could continue to fund services for people under the age of 18 is if you were funding them prior to becoming a region. That's why we can continue to fund our summer school program for our disabled kids out at North Middle that the mayor's daughter operates. That for Sarah Fame. I forget her name and I'm going to kill it. But those are the only reasons why we continue those programs is because they were funded prior to. Anything after regionalization, the individual has to be 18 years old.
And respectfully, and I know Shane said, well, this is something that Woodbury County has always done. And I said, precedence in Woodbury County isn't always a great teacher of what the...
But it's a great program.
I don't deny that it's a great program either. But my point is whether or not it's appropriate to fund through a mental health levy.
Everybody that attends the mental health meeting, okay, the public hearing, is members of the public that are interested in mental health dollars programs, and they voted for it since 2009, for this program, along with medications, housing, vocational programs, to be a priority for Woodbury County to fund. So it wasn't the Board of Supervisors making this decision. It was the public that have a special interest in these kind of programs that were saying medication is important to us. That's our #1 priority. Please fund that. Please make them available to people with schizophrenia and other types of diseases.
But prior to regionalization, it was the board making those mental health funding.
No, it wasn't. They were making that decision based upon the input that they got during those public meetings.
Right, but again, they were making those decisions. Whether or not they had input from other people.
I think you're playing words with me, that it's not fair. I don't feel that it's fair towards the program.
I guess my only question, and it's a brass tacks one, maybe I'll defer to the auditor. Prior to the region, was it not the role of the County Board of Supervisors to approve mental health expenditures, whether they had a recommendation from a group or not?
Yeah.
Okay, thank you.
Sure it was.
Right,
But
but
they got their information based on the public that told them and asked them what to fund.
I don't disagree with that.
So then why are we making that a bad thing?
I'm not making it a bad thing that they took input. I'm making it a dubious thing that when you had a sitting supervisor at that time who was the head of that center, for which
He never voted on any.
I know, and
I realize that
I don't
was
want to.
addressed later on.
Right. But I guess my
those
question is.
Can we please just, for both of you respectfully, don't talk over each other. It makes it hard for me to follow.
I apologize. Which one don't you have?
Yeah, these two.
Oh, the yellow, I don't know. So, I mean, I think to question the program is not to know the program.
And I guess I just repeat, I think it's a great program. Just don't know that it's the role of the mental health levy, just as I didn't believe it was the role of county tax dollars prior. And I don't think the public knew that it was not 186, it was more like 386, 925. Maybe now they will. But I do think it's something that the region, and Shane assured me that it's something that can be revisited because of his surprise that we were funding 5 FTEs through the mental health levy, and will do so into perpetuity for something that was once funded with federal funds that went away. Just my perspective.
Then maybe that's
Please, microphone.
then I think that's a standard that you have to apply to all programs.
Absolutely, and I think if we re-review some of those, that'd be a good idea.
And those potential and those possibilities are subject to every one of the programs we have. We've got Medicaid that comes and goes, and we have to figure out how we're going to pay for our disabled people to receive the services that they need. We're facing another battle again. Not a battle, we just have to put up with what gets passed congressionally, legislatively, and everything else. How we're going to get people those services and maximize the county property tax dollars to get them the program and the services they need.
And that may be we may be on the same page trying to do that with.
Someday we might have to give up the summer school program that had 102 disabled kids at it this year. We may have to give that up. We may have to.
Please, again, sorry. We have a supervisor that can't hear you otherwise.
But that's what it always comes down to, is prioritizing and utilizing those dollars to the best of our ability, based on what we know about the services and the needs of the people that we're providing services to. So, I mean, it's always in a state of flux. This is one of the programs, this is one of the priorities. Medications has always been a priority. That's decreased drastically because of the Affordable Care Act coming in and making more people eligible for medications, okay? We had to pay the state of Iowa back $600,000 because we were paying out over between $100,000 and $200,000 a year on medication. So that got covered by Title 19 now, so we can use funds to do other things. We're always but we have to remain, what we try to do is remain consistent in the quality and the number of services that we provide to people. And there's those critical ones, but this has been one of those priorities identified by the public. That's why it's been funded, and it works. We've got a number of other programs. Like I say, you really need to invest the time to see what programs we do have.
Thank you very much. I appreciate it. And just for the good of the board, I'll be looking for the region board to re-review this, as the CEO said, is certainly a possibility based on his conversations with me and seeing what was in the backup material in a new light, maybe.
I'll be providing the same information to all the folks on the governance board as well.
Yeah, that you did, and I appreciate that very much.
Any other questions?
No.
As well as talking into the microphone, I should really remember to bring some water with me because I'm like,
You know, I've had 5 of these, and I don't know if I'm going to make it to 7:25. But all right, thank you.
Did you have anything else on that?
I didn't.
Item 14, action items from Secondary Roads Engineer Mark Nara. Item A is to consider approval of contract and bond for project number HMA Route and Seal 2017.
HMA is hot mix asphalt roads, something we do every year to kind of protect some of the roads we've done in the past 10 years to seal them against water damage.
Any questions?
Second.
Discussion? Sorry, I'll second the motion by DeWitt. Did you second? I apologize.
I heard somebody.
Officially, Potabom seconded.
All right, thank you.
I was just wondering who here is a lawyer and able to make a motion, you know. All those in favor say aye.
Aye.
Opposed say nay.
Aye.
Passes 4-0. Item B is to consider approval of contract and bond for project number LBW 107-73-97.
And this is one of the projects in the capital levy. It's going to be completed. It's a 90-foot beam, single-span beam bridge, and the contractor's anxious to get going. So hopefully it'll be a construction that'll be completed by winter on this project. I move to approve this contract.
I'll second the motion by DeWitt. Discussion? All those in favor say aye.
Aye.
Opposed say nay. Passes 4-0. Item 15 is an action item from the Rural Economic Development Department Director David Gleiser, the Siouxland Chamber of Commerce Annual Dinner.
Good evening, Supervisors. David Gleiser, Rural Economic Development Director. This item is essentially being brought forth to you as I seek some consensus from the board on what the board's pleasure is on getting a table at the annual Siouxland Chamber of Commerce dinner. As you know, we are members of the Siouxland Chamber, and the Chamber does represent its membership by promoting the economic welfare and quality of life for the tri-state region. And this is a critical tool that the Chamber uses annually to raise the financial support needed to effectively achieve its goals. It's been sort of a mixed bag in the past in terms of what the county has done in terms of sponsorship. A few years ago, we did get a level 3 sponsorship at a cost of $1,900, which was paid out of my department's budget. That was in 2014. In 2015, we did get one general chamber member table for a cost of $800, which again was paid out of my department budget. And then last year, we purchased 2 general chamber member tables at a cost of $800 per table, so $1,600 total, which was again paid out of my department budget. In addition to seeing what the board's pleasure is on attending this event and getting a table or a sponsorship, I'm also seeking guidance from the board on what the practice would be for bringing a spouse. In the past, county elected officials and staff that have attended as a part of the county's delegation to the event have been able to bring their spouses, and if they do, they pay for it out of their own pocket.
Well, I think that practice should continue. I don't see any change to that unless the board has a comment there. I would anticipate attending. I don't know what other supervisors have planned that day. Feel free to speak up.
Me three.
I'd be more than happy to assemble the county's delegation, and in the past, what I've done is send an email to the elected officials and county department directors. I send an email to the elected officials first, see what their level of interest is, and if they'd want to bring a spouse, and then just work my way on down to department directors and then line staff level.
Sounds like a good plan to me.
I don't know if we need to go so far as sponsor a table, or sponsor, but a table, you recommended one, correct?
Correct.
Any comments on that?
So do we want to see where we're at once Director Gleiser's pulled everybody and/or talked to, and then come back? Otherwise, we're going to be doing it again, right? If you have a table for 10 and you find out that there's 11, it's either you're going to tell somebody no, or do we want to wait until you know a hard number?
Well, I don't know if you can buy half a table, can you?
No, but I'm saying if you need more than one table is my point. I mean, if everybody up here brought a spouse, you'd be at 10 people. And if you have other elected officials, my point is we could be at more than one table.
Okay.
So my preference would be take everybody's pulse and we'll see where we're at and then formally approve it. I know you waited a long time for that.
I guess I would also note that this is a first come, first served deal in terms of placement of the tables and where you're at, seating wise. Sponsors get closer to the speaker, and then it's a first come, first served basis. In the last 3 years that I've rounded up attendees, it's I guess if my recommendation would be to just get a table, and then whoever wants, if the 5 board members want to go and bring their spouses, then we can be satisfied there.
What happened last year? We had 2 tables. We had 20 spots. Were we like half full at one table?
It was difficult to fill them. Yeah, I don't believe they were completely full.
I don't anticipate bringing a spouse. Other members?
I anticipate bringing a spouse. I do.
I know usually the sheriff provides security detail.
Not this time.
I think we can make it work, but it's up to you folks.
If we're at 11, I'll be a team player and back out. How about that?
Are you giving the invocation this year?
Not that I know of.
I'll move to approve securing 1 chamber member table for $900 and paying for it out of the Economic and Community Development Department budget.
Just don't want you folks to get mad at me if you get a table and you're back at the end of the wall.
We were second to the back last time. It was okay. They have screens.
They have a good sound system.
So will you be sending out an email then asking who wants? Okay.
Second by DeWitt. Discussion. All those in favor say aye.
Aye.
Opposed say nay.
Nay.
Passes 4-1. Taylor opposed. Thank you. Item 16 is an action item from Board Administration. Dennis Butler, approval of operating transfer to fund the administrative costs for overseeing the county's flex plan.
Okay, what this transfer is, it does cover administrative costs for the flex program. The flex program is people that donate or contribute money from their paychecks for medical expenses. They get to deduct that from their overall salary. The savings to the county is about 16% on every 100,000, so we probably have roughly between 100 and maybe up to 200,000, so we save about 32,000 by employees going into this program. Their contribution does not cover administrative costs, so I've gone back 3 years from June 30th of this year back to 14. We had done this before. Nobody's really followed through on getting this money transferred each year, so I have come back with 3.5 years to make up the difference. then the fund is in the black again. In the future, we'll be doing this every year. I guess I'll take the responsibility of getting it done. Before, nobody did, so we're playing catch-up right now. Comes out general basic fund, and this will be done once a year. It averages around about 6,800, 7,000 a year, but by these people going into the program, it saves about 16 to 20,000 a year.
I'd move it.
Motion by Taylor, second by DeWitt. Discussion. All those in favor say aye.
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 Opposed say nay. Passes 5-0.
Thank you.
Thank you. Item 17 is the chairman's report. Item A is a review of the Policy Review Committee that was held June 29th. These are a draft of the minutes is included in the backup. Supervisor Raddick did attend, and that will be corrected for the final draft. The action you're welcome. The action that was taken related to an item on the consent agenda to remove outdated policies that Human Resources and the county attorney determined were either outdated or conflicted or needlessly were redundant to the employee handbook edition of 2016. Also, there was a undated, unsigned policy from sometime in the 80s, maybe even the 70s. There was no record of it ever being board approved, so without going to this board, the policy committee just said this is not going to be in you know, an extra sheet of paper in the handbook, policy book. We will continue to go through an old book of policies, for lack of a better term, that exists to screen them for updates. It's good practice to at least reapprove or update policies every 5 to 10 years, and we have several policies that are 20 years old and have never been revised and are probably in conflict with something else, which opens us up to, of course, legal issues. So we'll be going through those as we did. We covered 4 of them our last meeting. At our next meeting, we'll cover 2 to 4 again and go down that road. So even if we don't have policies that are new to be drafted, we still have a function to review, as the name of the committee suggests. Item B is an update on gaming and local option sales tax funds that the board requested from Dennis Butler. Just included it in your backup. It's current. There are some items which may be deferred to, you know, from fiscal year 17 to, from fiscal year 18 to 19, such as the first payment out of Lost and gaming for the Ag Expo Center, depending upon when that funding is actually requested. The updated plans, I don't think, have yet gone before the Sioux City Council, so it's kind of early, but we've already obligated that, so to our credit, it may be a boost in our balance for 1 year at least. Also, any other transfers the budget director might recommend could come through action on in December when we amend the current fiscal year budget, correct? Did you have anything else to add, Dennis, on how we're doing as far as the fund balances, what you see coming?
Very short. For gaming revenues, we will have $208,000 this year unallocated, and for local op sales tax, we have $142,000. That could grow, depends when the Ag Center goes through. We could be adding $75,000 on each one of those numbers if we defer to the following year. Also, we did talk about TrueSpeak a little bit, moving that over to the personnel department. We do have still 96.
Human resources budget?
Yeah, human resources budget. And we do that through a budget amendment, as Matthew did mention there. And we fund it for the current year out of the money left over from TrueSpeak in fiscal year 17 for $9,655. That we can do through a budget amendment, but at least we get it into his budget. And then in future years, it'll probably be tax supported if we continue the program. Or we can defer back to gaming revenues, have it supplement his budget for that amount of money, whatever we need. That's it.
The biggest disbursement, of course, from local option sales tax that we did recently was to offset taxes with the bridge replacement. And general supplemental. Any questions on this? It's a good thing to print out and have with you in case you want to refer to this. Fellow board members, it's always good to know what are in these two funds. There'll be a lot of demands on them in the future. Item 18 is reports on committee meetings.
Mr. Chair?
Yes.
Well, I'll be short because I'm through 4 batteries and I already took Supervisor DeWitt's. But Health and Wellness met, and it was actually a really, really good meeting. Life wasn't meant to be sedentary, and so we're really looking at health and wellness of employees on July 24th. Supervisor Potabom and I are going to lead the department head meeting, and we're going to make it all about being physically fit and emotionally healthy and happy. And looking at, he doesn't know this yet, but we're going to talk about CareBridge and how to get counsel as employees, and invite Natalie Oler and Dami Hughes, who gave an awesome demonstration of being physically fit and how you can do so at your workplace. Kevin Green's going to talk, and I've also invited Gary Brown and Rebecca Sacknett to do a little bit of emergency services management. Here's something that you can take in your own lives to be safe. So that's kind of the theme of the day. Right. And we're going to have healthy food, tofu and cantaloupe per Karen. So also doing Naturally Slim, 63 out of 421 people applied. If you can get 1 out of 7 employees to do anything, that's really good. I'm on it, and you will see a more svelte me in the future. So that's my report.
To see less of you.
I mean not. I mean quantity-wise, not quality-wise. Or vice versa. Okay.
Just so you know, no one's more emotionally happy than me.
That's why I thought we could team up.
Any other reports on committee meetings, Mr. Potabom?
I attended the Conservation Board. I mentioned before that they were looking at buying the new rifles. Those have been ordered, and their law enforcement people had requested to their board the right to do the similar thing what the Sheriff's Department did, and that was purchase those rifles through payroll deduction and pay the 100% back to the county with a written agreement that they have to carry those on duty. And I thought that was a good idea. One, it saves us money in the end anyway, and it gives them a chance to get a better price on a rifle if they're going to use it too. So just to let you know that their board did approve that, and they're moving forward with that. And they are also, this month they will be moving forward with the process of looking for a replacement for a long time director.
Mm-hmm.
No Siouxland District Board of Health meeting this month, but we came in and approved claims.
Item 19 is citizen concerns. Item 20 is board concerns. Hearing none, we are adjourned.